Okay, let's just give the attendees another moment or so to join us. The number of attendees who are joining by Zoom has largely stabilized. So I just wanted to start by saying good morning. Welcome to the State Bar of California's Testing Accommodations Stakeholder Input Forum. My name is Donna Hershkowitz, and I'm the Chief of Programs for the State Bar of California. We really look forward to hearing from interested stakeholders today as we examine our existing rules, forms, processes, communications, website, and the like that touch on the process for requesting and getting testing accommodations on the first year law students examination and the California bar examination. As we began the process of formulating ideas for what we think is ripe for improvement, we knew that seeking the input of stakeholders, those who've requested, will be requesting accommodations, those in the disability rights community, those and others with valuable expertise and experiences, is an essential component for ensuring that we are appropriately addressing the needs. Stakeholder comments are welcomed on all areas of the testing accommodation process. We've highlighted in the item that was attached to the agenda posted for today's meeting the broad areas where input would be most appreciated. Throughout the day, we'll be taking public comment from 3 separate venues: at the State Bar's San Francisco office, at the State Bar's Los Angeles office, and via Zoom. Because it's difficult to queue up when we have 3 venues, we'll rotate through the venues, taking 2 people from each before moving on to the next venue and then circling back. To ensure the ability to hear everyone, public comments are going to be limited to 5 minutes today. At the end of your 5 minutes, the coordinator will call time and we'll move on to the next commenter. We have also provided the opportunity to submit written comment. And although the agenda suggested that written comment should come in by today's date, we will obviously continue to accept and review public comment that we receive. And we encourage those of you who don't feel like you were able to convey your thoughts fully today to submit written comment. The email address for written comment is included on the agenda item. Just a couple more logistics. For those of you who are participating via Zoom video, you should see a hand icon at the bottom center of your screen. Click on this to virtually raise your hand and indicate your desire to make public comment. For those of you who are participating by phone, you may virtually raise your hand by pressing the star key followed by the number 9. And as I said, the coordinator will call members of the public, starting with 2 in person in the San Francisco office, then the first 2 in line in the Los Angeles office, then 2 on Zoom. For those participating via Zoom, once the coordinator calls on you, we will enable your microphone so you will be able to speak and we can hear you. And finally, although this is a public forum, we obviously want to respect your privacy to the best of our ability. For those participating via Zoom, when you are speaking, the name you have identified yourself with on the Zoom app shows up on the screen. So I want to encourage you to feel free to change your Zoom name to just your first name or other name, so that your full name is not showing if that is your preference. We'll also endeavor to call individuals by their first names only, even if you haven't changed your Zoom moniker. For those appearing in person, you should also feel free to identify yourself by your first name and not necessarily your full name. For those calling in by phone, commenting by phone, when we call on you, we'll identify you by the first 4 numbers of the phone number that's showing. We will have with us today and have with us now members of the Committee of Bar Examiners and leadership of the State Bar of California. On behalf of the staff and the members of the Committee of Bar Examiners who are here now, or those who will be here later today, I just wanted to conclude my remarks by saying how much we appreciate the time that you are taking to share your ideas with us. I apologize ahead of time. I will actually have to step back to a meeting for just a little bit, but I will be back later today. And with that, again, thanks to the members of the Committee of Bar Examiners who are joining us to hear this very important stakeholder input. And thank you to the stakeholders who are giving themselves and their time to us today. Devin, I'll turn it over to you then to begin the process of calling for public comment, starting in the San Francisco office.
So at this time, we do not have public members at the San Francisco office, and I think we can turn it over to see if LA has people. And I do not see people in the Los Angeles office as well, so I think we can go to the Zoom attendees.
Okay, we have Ms. Charlene Desarendez. I will mute the mic and you have 5 minutes.
Hi, I spoke with Audrey Chin and she said that I could request to read a statement in addition to myself, but for Juliet Chandler. So I need to know if that's going to be approved.
Go ahead, Charlene.
Without it taking time from my statement.
So you're going to make a comment on behalf of 2 people?
Yes, one for myself and one for Juliet. Audrey Chin, the assistant director, said it was okay.
Okay,
Yeah, go ahead, Charlene.
Thank you. So for Juliet Chandler, I have her permission to read this statement. She says, I'm going to read it from her position. I was diagnosed with an autoimmune disorder during my last year of law school in 2003. I failed the bar exam twice and decided to stop trying. 17 years later, I decided to try again. I applied to take the July 2021 bar and was denied accommodations initially. I was told that I did not have enough evidentiary support for my request. Perhaps it was because I did not receive accommodations in law school or during my bar exam attempts to bolster my case. My disorder is unique and I have not been able to request to find a specialist in my town that can vouch for my disability. I suffer from severe fatigue, especially when provoked by stressful conditions. I know I will not be able to take the bar exam without accommodations. After I was denied accommodations last July, I panicked and withdrew and forfeited my registration fee before the July 2021 bar. I received an email later informing me that I was given time and additional time for each portion of the bar. I wish I had received this early enough to appeal the partial accommodations I was given. I requested time and a half and to split the first day of the exam because I do get fatigued. It's my mistake to assume that I would receive both accommodations as requested, but it was not addressed in the letter. I did not realize this oversight until my husband pointed it out. I tried to reach accommodations office to ask, but I kept getting a voicemail message. I tried sending general request messages to the applicant portal, but I did not get any responses. I finally got through June 1st, not knowing this was the last day to apply for an expansion. One of the staff, Maria, at the office was gracious and kind and walked me through the process. I just got lucky to be able to send the expansion request on the day of the deadline. I'm still waiting for a response, but I do want to update that I personally know that she did receive a response last night at 7 o'clock. She had a few suggestions to make the accommodations process more user-friendly, to create a special portal for applicants entitled Accommodations Purposes Questions. Denial of accommodations email should include approved and non-approved accommodations to avoid misinterpretation. And then denial of accommodations email should list what specific evidence is needed that is lacking to support an appeal of the denial. to appoint staff with a cohort of accommodation applicants so an applicant can have someone specific to ask if we have important questions about our application. I only ask to be able to compete on par with my co-bar takers who do not have my disorder. Thank you for your consideration. Sincerely, Juliet Chandler. So I'm done with hers.
Okay,
And
thank you. And we'll give you your 5 minutes.
thank you. Good morning. My name is Shirlene Claich. I'm 53-year-old mother, former elected official. I have worked for local government and served on numerous local boards, commissions, and committees, and worked for several big law, mass tort, class action firms, managing thousands of clients. I have navigated several learning disabilities my entire life, and in the last 20 years, also developed permanent physical disabilities that are not only painful every second of the day, but also limit my physical activities in significant ways. I went to law school in my 40s with 2 teenage sons in high school. My initial testing accommodations were approved without a single issue when I first submitted them several years ago, but I spent thousands of dollars and hundreds of hours of my time gathering all the necessary paperwork to ensure it would be approved. I initially took an ADA law elective class during law school, so I would know the law behind the testing accommodations process. My problems began when I signed up for a subsequent bar exam test and requested the same testing accommodations as previously granted to me by the bar admissions office. It was a nightmare. Yesterday, I spent over 8 hours writing a 12-page statement for this forum with detailed issues, solutions, and examples. I could easily have written 50 pages, but I ran out of time. I submitted it as instructed, and I challenge each of you to actually read it and ask the much-needed follow-up questions, since this forum is not designed for meaningful dialogue. After reviewing everything that I've experienced with testing accommodations process and hearing stories from dozens of other exam takers, I truly hope that the decision makers are paying attention and really listen so that meaningful changes are implemented. I do applaud you for holding this forum, but it is not designed for dialogue. The best way to describe what I have experienced in the mere 5 minutes allotted to each participant is by saying, this is my victim impact statement. Yes, I've felt like a victim, and there are others who feel the same as I do. Some are actually scared to say anything for fear of retaliation. I'm not scared to speak my truth. Applicants should be denied based on lack of merit, not because of staffing error, lack of staff to process the applications timely, or because they come from a country that didn't test for learning disabilities in elementary school or keep those records. They didn't have learning disability programs when I was in elementary or high school in the 70s or 80s. The process needs to be expanded and adaptive to be more inclusive, not restricted and reduced to be more restrictive to potential applicants. It should not be easier to get approved for permanent Social Security disability benefits than it is to take an outdated exam. The accommodation should be similar to what law schools do, or it unjustly prevents law school graduates from obtaining the same testing accommodations as they were granted in law school. I've been treated as if my life doesn't matter throughout this entire process, from the design of the website and applicant portal to the division head's lack of significant training in the field of learning and physical disabilities. This person is not authorized or qualified to make decisions that impact my life. We are punished by mistakes made by staff at a significant financial, emotional, and personal cost to us, but there are zero consequences to the staff members who fail to return phone calls, emails, misplace our paperwork, or apply the wrong policy to our particular situation. I should not have to educate the staff on what their policies are and how they should be implemented. Specifically, when I requested the same testing accommodations as previously granted to me by the bar admissions office in a timely manner for the July 2021 bar exam, my paperwork was nowhere to be located, yet nobody bothered to call and tell me. I waited, I called, and I emailed again and again with no resolution. After months of finally waiting, I finally got my previously accommodations granted only a few days before the exam. It had errors. I was being asked to test for almost 11 hours a day. This was completely illogical, given fatigue is one of the factors for my accommodations request and was specifically detailed in my approved accommodations. There was no common sense being applied to my request. I had no time to modify the mistake, and despite the mistake being by a staff member, I did not even get a refund. There is no policy that does not allow for a refund of staffing errors on an approved testing accommodation request. The policy only states there is no refund for those who withdraw from the exam if their accommodations are not approved. A staff member error cost me over $800, and I lost 3 months of study time and time off work to study. Almost done. There's been zero accountability by testing and accommodations divisions. I strongly believe that the policies are designed and implemented are in violation of ADA law. Unless significant changes are made voluntarily, the admissions office will be encouraged to make the needed changes by the Department of Justice. If our accommodations are approved with errors by staff, exam takers should receive a full refund of their application fees. Exam applicants should not be punished further because of any staffing errors or untimely processing. It needs to be a collaborative process. It needs to have dialogue between everybody. And I really hope this is the first step for meaningful changes. Thank you.
Thank you, Ms. Shirley. And I guarantee you that we will read the public comments that you have submitted. So thank you for doing that.
Thank you. I really appreciate it.
Have a good day. All right, next we have Mr. Jewel Sarkar. I will set your time right now. Let me unmute you.
Thank you, Ms. Nunez. Good morning. My name is Jewel Sarkar. I represent attorney applicants against the State Bar of California and NCBE's unlawful admissions practices. Today, I believe we have heard and will continue to hear from some applicants and advocates about specific technical problems they've encountered during this process. I want to address some of the broader root causes of the State Bar's discriminatory anti-disability practices. At an early 2020 Committee of Bar Examiners meetings, one of my colleagues began discussing her mental health disabilities and the impact of her being forced to proceed through the pandemic. But a member of the Committee of Bar Examiners interrupted her, shouting, "Oh, shut the fuck up." Despite my ethics complaint to the Office of Chief Trial Counsel regarding the committee and the Office of Admissions' various ethical and criminal violations, the State Bar did not investigate that committee member and bring him to justice. And he continues to sit on the committee, demonstrating that his position of, "Oh, shut the fuck up," is indeed representative of the State Bar's position on disability accommodations. The State Bar has further displayed its discriminatory intent at many of its other Committee of Bar Examiners meetings, where Office of Admissions employees openly complain about how disabled applicants are making it difficult for the State Bar employees to make themselves rich off of this process. Most of these complaints are by State Bar employees, are never substantiated by truthful fact, such as Tammy Campbell's allegation that an applicant's use of his First Amendment right to the petition to redress in our courts was driving up the cost of the exam. More recently, the Office of Admissions has tried to amend the State Bar rules to allow them to withhold accommodations decisions until as close to the exam date as possible and to ignore any challenges after the fact to wrongful last-minute decisions. Whatever short-term benefit the State Bar has gained from employing these individuals and allowing them to financially reward themselves for discriminating against disabled applicants may have been nice so far, but it will cost the State Bar many, many times over when it is finally brought to justice. Even if the State Bar attempts to modify its accommodations process based on today's input for the better, those attempts will be challenged and thwarted by its very employees, who have repeatedly shown their inability to set aside their deep and personal disdain for allowing disabled persons entry to the legal profession and their belief that persons with disabilities attempting to enter the legal profession are somehow competing with their income. Finally, I also need to address the State Bar and NCBE's mutual agreement of sending disabled applicants back and forth to one another for questions regarding disability accommodations. These applicants are disabled. They're not stupid. Many of them have made more attempts to take the bar exam than the NCBE's diploma privilege attorneys ever have in their lives, which is zero. If the State Bar is unable to make the NCBE compliant with the relevant disability rights legislation, it should not partner with them at all. Because this meeting gives the public the impression that the State Bar intends to improve its disability accommodations application process, I also request the State Bar subsequently provide a detailed report of any efforts that are made to do so. If we don't see any evidence, I think that'll tend to show that this meeting did not serve that purpose. Thank you very much for your time and your consideration.
Thank you, Mr. Sarkar. All right, so I'm going to check in with both the San Francisco and Los Angeles office. Do we have any members wanting to make a public comment in person?
LA here, we don't have anybody here yet.
Okay.
San Francisco has none either.
All right, thank you. Then we'll go to Ms. Michaela Martin. Are you there?
Can you hear me?
Yes, we can hear you now.
There we go. Okay, fantastic. Thank you for hosting this meeting and having the space for folks to speak out. I do want to say that it did seem that the person who introduced this meeting said, thank you for being here. And also I'm going to leave now. And that sets a tone for how it kind of feels about this process. I wish I could say I was denied, but they're calling it an administrative withdrawal. And I so far know of 8 other students from my school who've experienced the same email asking for additional information that was not requested on the application. And as it's being considered incomplete, we're not given the opportunity to appeal or really talk about the process at all. For me personally, I've been diagnosed PTSD for many years, and I was told that I needed comprehensive evaluation based off of not subjective notes or self-reporting, but nobody so far has answered how I can show that I have PTSD without self-reporting of trauma and symptoms. I don't know how to get that information. I've called the bar half a dozen times. I've emailed back and forth. They keep referring me to the website. The website gives me no information about what is needed for me on future tests to be able to comply with that requirement. So I ask, one, for that to be outlined. If you have special additional requirements for particular diagnoses, that should be transparent on the front end. Also, I've asked who is looking at these applications. My psychiatrist had issues with how much they're asking for in the notes because that's very personal information related to my trauma that I don't necessarily have any assurance is going to remain confidential when it's given to the bar. I don't know how to deal with that, and nobody will give me answers or respond. And so my main ask is I echo what's been said about, not being able to have our fees returned. That was $830. I'm a single mom and I live on Section 8 housing. I don't know how I'm going to do this again, right? So I'm going to take a test that I'm very likely to fail. And I don't know how I'll be able to retake it. I don't know how I'd have access to what they're asking for. And I don't know what's being asked of me. And I think that that's a serious injustice. So, well, I thank you for your time. I hope that this is a serious process in which we'll really look at transparency. I'd also really like to know who's looking at my application. Are these just staffers? Are you asking for is this an actual psychiatrist who's looking at the validity of my doctor's notes? Why? I have a lot of questions that nobody will talk to me about. So hoping I'll have some more answers here. Thank you for your time.
Thank you, Ms. Martin. All right. Next commenter, Ms. V. Soto. So V. Soto, I'm going to unmute you and allow you 5 minutes. Are you there? V. Soto? Are you there? V. Soto? Okay.
They've been given the mic and they're also unmuted.
Yes. All right. Why don't we move on to Kelsey Goldman, and we'll come back to V. Soto if you keep your hand raised. All right, Ms. Kelsey Goldman.
Hello. Can you hear me?
Yes, we can hear you. Thank you.
Hi, my name is Kelsey Goldman, and I'm a recent graduate from UC Irvine School of Law. I'm currently serving on their Diversity, Equity, and Inclusion Committee. And while I was attending the school, I formed a chapter of the National Disabled Law Student Association. I have a lot of experience advocating both for myself and for my fellow students to get accommodations, as well as to implement principles of universal design in the education system. I also have personal experience applying for bar accommodations and have been actively involved in other colleagues of mine's application process. I think that the other commenters have done a great job of explaining a lot of what is wrong and a lot of why change needs to happen. What I would like to do is to give some suggestions on what those changes might be, because I feel like that might be where I could be helpful. First and foremost, I think that one thing that is very different from most accommodations processes compared to the bars is that the bar exam does not leave open a collaborative, interactive process as is required in every other institution, including employment and education, that I have experienced. In many cases, court cases regarding the ADA, it's explicitly said that the accommodations process must be collaborative and interactive. However, all we are able to do is submit papers. We never get to talk to anybody. We never get to explain verbally. I think that creating an appointment system to discuss accommodations similar to what is required in the university system would be a great step. For example, then you can talk to somebody and understand what to expect on the bar exam. You can share your symptoms and they can give you suggestions as far as what accommodations might be helpful for you as an individual, and you can get individualized accommodations. Additionally, you can create alternative solutions to unique problems. For example, I requested an accommodation which was denied because it was considered impractical for the bar exam to accommodate it because it was a remote test taking. However, I was not able to discuss with somebody what other accommodations I could have instead if I have to take it in person. Instead, they came up with what they thought would be acceptable without my input. Several things that I require were left out of that, and I have no recourse to discuss back and forth because this was already on appeal. So having someone in person who could say, oh, we're not going to be able to grant that, but let's discuss what alternatives there might be, would be extremely useful. Additionally, it is just easier to explain certain issues in person compared to on paper. When you write on paper, I suffer from joint dislocations, that is going to be received differently than if I'm in person and I'm telling you, look, all of these joints on my body are dislocating. This is what happens. I cannot use my finger. I cannot type when this occurs. I need to have a caretaker present to relocate my joints. And it just being in person, or at the very least on Zoom, makes a really big difference. Additionally, the test is very different than any test experience in law school. It has different restrictions. I never needed to request that a test not take longer than 6 hours a day. I never needed to request that I had water available during a test because I was always via universal design granted those accommodations along with everybody else in my university setting. Because I don't have those, on my history of accommodations, it seems as though the bar takes that negatively as if I do not need them, rather than I did not need them because they were already being accommodated. I think that the bar should take that into consideration, and I think that having that interactive, collaborative process would be helpful. My other main suggestion is on the concept of universal design, which is generally described by disability justice advocates as being the optimal situation, where instead of forcing disabled people to go through lengthy and costly accommodation processes, everybody is accommodated in a way that makes things more possible. The way that I think that the bar exam could have principles of universal design is to create an alternative exam that you could choose between that would not have some of the same issues with disability. For example, if you went to an accredited California school, there could be a number of supervised hours that you had to complete pro bono, along with a letter of support from a supervisor stating that you are competent, that you have minimum competency. Alternatively, there could be an open book, untimed skills test that has a heightened standard and is more similar to actual lawyering. These things especially.
Sorry, we've reached our time, but I think we have enough time so we can hear the rest of your statement. So please continue. I know we're going to go a little bit beyond 5 minutes, but this is really important. I think you're.
Thank you. I'm just about done. Okay. I apologize for going over.
All right.
So yes, an open book untimed skills test with a heightened standard, more similar to actual lawyering. These two alternatives, which would be available to anybody who had went to an accredited California law school, would not require the strenuous issue of asking for accommodations, especially for those people with disabilities that relate to memory and memorization, something that is not generally required of lawyering, but is extremely intensive on the bar exam, as well as time limits for those of us who have issues with fatigue or other constraints. I think that kind of universal design would be effective in ensuring that everybody who is a lawyer in California has minimum competency without requiring this alienating and distressing process for disabled people, and would protect the bar exam as well from discrimination claims, as these accommodations would be in-baked and they would have less issues with potential discrimination. I appreciate your time. Again, my name is Kelsey Goldman, and I welcome the bar exam and committee to reach out for further discussion on these potential solutions. I will send in a written comment with my contact information. Thank you very much.
Thank you so much, Ms. Goldman. All right, and with that, I think I will go back to V. Soto. I'm gonna unmute your mic and see if you're available to now make a comment. Are you there, V. Soto? V. Soto? Okay. All right, so why don't we move on then to Diego Garibay. Are you there, Diego Garibay?
I have been unmuted.
Hello.
Not Diego.
Yes, who said that?
This is Abigail Unruh. I'm not sure if I was unmuted by mistake.
Yes. Okay, I've muted you. Abigail, you'll go next, but we have Diego on board now, right, Diego?
Yes.
Okay, so Mr. Garibay, please start your comments.
Hello, I am Diego Garibay Valenzuela. I have just successfully taken the first year law exam, otherwise known as the baby bar, yesterday. I am completely blind. Both of my eyes were removed, and I submitted over 50 pages of paperwork and was approved for all my accommodations. Frankly, I believe because my particular physical disability was so obvious and direct that there wasn't really much wiggle room in there. I just got no eyes, and that's what that is. Now, as for taking my exam, I will say that the people who administered that exam yesterday were all, each and every one of them, very good people. They were there to do their jobs, did them well, and did not, how can I put it, dilly-dally or waste time or ask for things they were not told to ask. They knew their jobs and did those very well. Now, as for the things that I would suggest, first of all, and as has been said before, your application of universal design to a website, a test, or anything else is an incredibly good idea, because I, being a very advanced computer user, had to, or let's see, how much did it take? I don't know. Let's call it maybe over 10 minutes. Learn to use your system for submitting my accommodations, for selecting what I had selected again, for ensuring that everything was uploaded correctly. Also, when I uploaded my letter, my accommodations request, for some reason your system uploaded it slightly differently, put page 8 in front of page 6 in front of the other page, and one of my accommodations, which was a headset, was missed. I had to submit an emergency request, got very lucky, and was able to get it approved. Also, when I was taking the exam, I was only given a 5-minute warning and a end of the exam warning, as for the first part of my multiple choice exam. I then asked if I could get a 30-minute warning, and I was granted it. That is fine. I would like to be able to ask a person to look at a clock, which is something I cannot do, and let me know how much time has passed whenever I need to do so. I was also told that I could bring an analog watch. I then said, could I bring a Braille watch? It is completely analog, and was told to add that into my accommodations by calling. An analog watch and a Braille watch are the same thing. Let me think. I must also say that I, with my physical disability, could have taken this test remote if I was simply allowed to have my computer monitored, completely if you will want it, and then run my Word document, my Dragon Naturally Speaking, which is the software I use to type, and make another document to put the questions into. I could have easily sent that in a system like Dropbox. I mean, I would use that because it's slightly unsafe, or any other file upload service. Lock down my computer, monitor all my activity, listen to my camera and my microphone. I know what you guys are going through and I understand it. If you want to fully monitor it, that is fine. The only reason I and my entire family had to use more than $100 of fuel and drive more than 2 hours is so that someone could calmly sit, look at me type, and then take my exam. And as for the reader, she and everyone else, as I said, was wonderfully good at doing their job, and they provided all the accommodations that I was granted. But honestly, I think I got lucky, very lucky, in having a successful accommodation request, if only because my particular disability was extremely, extremely obvious. I thank you all for your time. Besides being able to ask for the time whenever I may please, because I need it so I can time myself when I'm doing a multiple choice, and so does everyone else, as we all have done when we can see the clock. I would not ask for anything else, and of course, you all are overstaffed, and calls and emails take about a week to return. Thank you so much.
Thank you, Mr. Garibay. All right, so at this point, I want to check in with either the San Francisco or Los Angeles office. Do we have anybody in person wanting to make a comment?
LA here, we still don't have anyone in office.
Okay. All right. So we'll move then to Miss Unruh Abigail.
Yes, hello.
Okay.
I first would like to state that I concur with Ms. Martin's comments on the tone that is set for the meeting by the initial staff member leaving. Now, as to my particular disability accommodation request, I applied for reasonable accommodation after discovering that I was pregnant and that my child's due date falls 5 days after the administration of the July 2022 bar exam. I was first shocked to discover that the bar will not provide alternative testing days for any disability. And when I inquired what reasonable accommodations the bar would be referring to if rescheduling is not permitted due to imminent childbirth, I was informed that depending on a doctor's recommendation, a pregnant woman may be permitted to take in food and water and have accommodations such as stretching breaks. I proceeded to submit a letter from my doctor attesting to my pregnancy and due date and requesting several reasonable accommodations. I was told that this letter was not sufficient proof of pregnancy, as if I had somehow convinced a doctor to fraudulently certify that I was pregnant and what my due date was. I was forced to provide ultrasound results to verify my pregnancy, which was insulting and invasive. And even after providing this documentation, I was told I also had to in detail explain the nature of my medical condition. Confused, I asked a bar employee, "Are you saying I need to explain in detail what the condition of pregnancy refers to?" She responded affirmatively. I then had to submit a letter wherein I explained to the state bar that pregnancy refers to the condition of a developing fetus in a woman's body and the changes that entails. Can anyone explain to me why this was necessary? After complying with all of the excessive requests, all but 2 of my accommodation requests were denied, despite the attestation of my doctor that they were necessary to accommodate my advanced pregnancy. To my knowledge, the State Bar Accommodation Committee is not comprised of doctors and should be required to give deference to the opinion of a medical doctor, unless the bar is asserting that an OBGYN reviewed my doctor's recommendations and deemed them unnecessary, which I believe you are not. Despite stating at the time of request that I was already suffering from frequent urination and my doctor's approval, my request for time for extra bathroom breaks was denied. This places me at a direct disadvantage due to my disability, and the symptoms of my condition have only worsened since the initial application. Most disheartening of all, the request of my doctor and myself for a private testing area for me due to the likelihood of me experiencing contractions during the exam was denied and deemed speculative. This has now become my reality as I have been medically treated for preterm painful contractions for the last few weeks, and this will continue until my child is born. I will not have the freedom to perform breathing exercises or make any noise despite being in pain during the exam due to the bar's refusal to provide me such a minimal accommodation. Should I even attempt to update my request due to the aforementioned symptoms, I have no doubt the bar would simply deny the request, as they have previously demonstrated that they disregard medical opinions and necessary requests. What does this process say about the value the state bar places on women's health? Unfortunately, the only conclusion I can draw from this decision is that the state bar does not truly recognize pregnancy as a serious disability and is willing to disregard it as a woman's issue unworthy of actual accommodation. Additionally, the process for updating a request or submitting an emergency accommodation request is confusing and apparently precludes the occurrence of emergency disability requests submitted after June 1st, 2022 regarding the July 26th, 27th exam. This is a serious problem for me, as my child could be born prior to the exam and change the nature of my disability. I obviously will not know whether that is the case until after the birth, at which point I would need to file an emergency petition to accommodate pumping, as I will be a breastfeeding mother. However, your website appears to state that such a request would be dismissed as untimely. What would the bar have me do in the instance that my child is born early and I cannot get a pumping accommodation? Should I choose to pump in the room with all of the other examinees or forfeit hours of my testing time to exercise my legally protected right to breastfeed? I really look forward to a response advising me how I should proceed on this issue. And what does the bar expect people with emergencies which arise after your arbitrary deadline to do? There are a number of people besides myself who could find themselves in situations with emergencies which arise after the June 1st deadline, as is the nature of emergencies. The bar's accommodation process is in desperate need of updating, both in procedure and substance. No examinee should find themselves in my situation. And it is my opinion that the California State Bar's reasonable accommodation process should be renamed, as it appears there is very little accommodating of disabilities, and the accommodations which are granted are certainly not reasonable. Thank you.
Thank you. With that, we will move on to our next comment, Mr. Thomas Walker.
Hello, can you hear me?
Yes, we can hear you. Please start, Mr. Walker.
Okay, thank you for the opportunity. But I have a disability of macular degeneration, which affects my eyesight. And also I have diabetes, which is my main testing accommodations. I have not applied yet for diabetes. I passed a law school to begin testing in the Cal Bar examination roughly around 2012, and you know, I did not develop my macular degeneration until 2014, and so I had to experience that even while I was taking the bar exam. And I could not finish my exam, and so I went to the doctor. I had it treated, and the diagnosis is macular degeneration, which is a permanent condition. It does not get any better, and it's irreversible. As I was reading on a online Google the definition of macular degeneration, and I have intravenous eye shots by a needle every 10 months, which is required, or else it'll get worse. So I'm just stabilizing it at this time. And I have been approved in the past for accommodations for a time and a half on the test, exactly. And because that's what I thought I needed. I didn't overdo my request, but you know, as I'm taking my test, I also have diabetes, and there are times, especially in the afternoon, where I need something to put in my body because of my blood sugar level. I have not yet applied for that. And I think because of the difficulty of obtaining a testing accommodation, going through all of the verification, the paperwork, and even coming to the point now that with my macular degeneration, which is a permanent condition, it's not going to get any better. I am required to renew the application. In other words, start over. And I want to bring to the fact that the problem this is not only on my behalf, it doesn't not only affect me, but my doctor has to redo all of the paperwork. And so I'm being placed at the mercy of a third party here. And I believe I have asked him to redo the paperwork in March, and I'm still waiting on it. And the last time I seen him was about 3 weeks ago, and he asked me when my next time I'm going to take the bar exam. So I'm telling him in February, and hopefully I'll have all of this accommodation paperwork approved, but it depends on him. See, and he obviously wasn't ready to complete the application for me, and I can't force him to. I don't have any pressure over a doctor, and it's their voluntary filling out of the application. So this is what the bar exam has placed me at the mercy of a third party when my condition is permanent. See, and I have not yet even applied for diabetes, which I really need to have a snack in the middle of the afternoon, because it's like I'm like going through a desert. I can't describe the body of diabetics who need food or a drink to keep their blood sugar level at an appropriate level. So I heard some comments earlier about whether or not there are professionals such as doctors at the Cal Bar who are reviewing these applications, because my conditions are physically permanent. They're permanent, and I don't believe I should be going through having to renew an application that is a permanent condition, and I should not be distracted in this manner while I'm trying to study for this bar exam. That's very frustrating, because I believe the doctor believes the same way. And he mentioned something to me about it, which was, I'm not going to share because I don't want, it's not to reveal the confidentiality of the doctor's name or what he said, but it was obviously he was not believing in this process that is being, part of the California bar testing accommodation. And I know he believes that it's permanent too. Why keep filling out applications about it? So that's my main concern. And so I just want to let you know that this process is flawed if it's not being accurately applied and not being having the doctor's credentials being accepted. It's kind of doubting the whole system when you cannot believe what a doctor, an eye doctor at that, who is professional, who's been in has decades of experience, knows what he's doing. And so I didn't anticipate getting vision problems while I'm going through this process. And it's been a long time since I've started studying law, and this is not what I anticipated. But I believe that it's a process, and I believe the process needs to be reviewed, and things like physical permanent conditions need to be accepted as such. And I'm going to leave it at that. Thank you.
Okay. Mr. Walker, thank you so much. Thank you for giving us an account and a suggestion based on that account. So thank you. Let me check one more time with either the San Francisco or LA office, if we have anybody present there to make comment.
LA here, we still have nobody present.
Okay. Well, thank you. Then let's move on to Brendan Wilson. Brendan Wilson, are you there?
Let's see. This is Brendan. Can you hear me?
Yes, we can hear you, Mr. Wilson.
Great.
When you're ready, you can start.
Great. Thank you so much for this opportunity. I greatly appreciate it. And I also appreciate the comments that have been made by the people that have spoken so far. A little bit of my background. So I'm a veteran. I had 12 trips to Iraq. I was eventually medically pulled from Iraq for PTSD and a traumatic brain injury. I lost my job. I was dismissed from my job for that reason. And the Veterans Administration treated me and diagnosed me as permanently and totally disabled, unemployable, and housebound. As part of that, there was documentation of a cognitive impairment. And when I came to do the application, my VA psychiatrist, who had treated me from the time that I was first diagnosed until the present, had recommended that I just provide the neuropsych report, which is very extensive. It's the full psychological aptitude of a patient at that time. And then he filled out the required forms for the state bar. What I got back was a denial, and I had a couple of comments on that process. The first one is the adversarial tone. So it really sounded like sort of an insurance defense. What I had expected was that the state bar would say, here's our standard for applying accommodation for extra time because of cognitive impairment, and here's what you have done, and here's how they match or they don't match. And instead what I got was sort of a point by point where they were disagreeing with it. And some of that didn't seem fair. And this sounds minor compared to some of the other comments that we've heard, but I felt like they had cherry picked the data. So for example, if you look at any neuropsych report, you're going to see things which are negative and some things which are positive. So the reviewer in this case, this is just one example, looked like they were looking for anything that was in the normal range to say, you don't have an impairment that's worthy of a accommodation. So for example, the impairment is very clearly stated. And then they said, well, your psychologist says that your IQ is within the normal range for someone your age and education. And therefore, the assumption being that if you have a normal IQ, you don't need an accommodation for this. They also started asking for information, which I had not anticipated, and I do not believe is required for the initial submission. So other people have mentioned this. And my view is if you're going to raise an objection that I didn't know was a requirement, that you should just ask me for that information as opposed to denying the request, saying that the information is lacking. Let me give you an example of that. I was granted an accommodation from my law school midway through my legal education. And they had said there's no evidence that there was any change in your academic performance before and after your accommodation. So I, on the appeal, I said, here is my grades. Here was the date of the accommodation was granted, and my grades went up. And the response that I got back from that was, you haven't provided enough specific information. I don't know how that could be any more specific. Another thing, they said that, yeah, your doctor says, that you have a TBI and a PTSD, and that's the cause of your impairment, but it could be something else too. And you haven't told us enough information for us to make a determination of the actual causes of your impairment. To me, that sounds like in bad faith, because if I have an impairment, I don't see what difference it makes if there are additional causes that would contribute to that impairment. One of the other things that I was a little bit surprised at is that the reply came to me via email, right? So I had made a submission, but that email included information which had been taken from the secure server where I made the submission to the first place, and it had been pulled out of my neuropsych report and then put back to me in an unclassified email. And I considered that a violation of my privacy under HIPAA and FERPA. I didn't think that was necessary because they could have just simply responded to me using the web portal, which is secure from the state bar. And I felt that that was really unfair. And then as a final note, I was concerned, as other people are concerned, that the document was unsigned. So, and I'll just give you an example. My psychiatrist is board certified in psychiatry, board certified in brain injury medicine, and board certified in behavioral neurology and neuropsychiatry. Whoever has written that denial and the denial of the P or partially approved appeal, right, is presuming to tell my board certified psychiatrist that he's not qualified and that his judgment of the patient, which they've never met, isn't suited. And I think that if you are going to presume to overrule a qualified physician, you ought to put your name on that and your position and your qualifications. I'm sure my psychiatrist would like to know who it is that's telling him that he doesn't know his business. Anyway, and I guess, but the most important thing to me is that I don't think that if you're going to deny an appeal because you say that you don't have enough information and you are raising issues which have not been raised and are not required in the initial application, that's fair. I think if you have new issues, you should say, we need more information. For example, when I filed my appeal, I answered every single objection which had been raised, every one. And when they came back to me, they raised new objections and then only partially granted the appeal. And I don't think that's a fair process. I realize that other people have had it worse than me, and other people have other problems that are worse than mine. But I do think this process could be better. It doesn't need to be, in my mind, an adversarial process. You either meet the standard or you don't. I think we would be happy with that. In this case, I felt like that it had been done in bad faith, and I thought that my service as a U.S. veteran who's totally and permanently disabled, unemployable, and unable to leave my house without assistance, that had been disrespectful of the position that I've been. Thank you very much for listening to me. I realize I sound a little bit angrier just because I get worked up, and I appreciate your patience in listening to me. Thank you.
No problem. Well, thank you so much, Mr. Wilson. All right, we're going to move on then to Mr. Cohn. Are you there, Mr. Cohn? I'll start your.
Yes, hi, I'm here. Thank you.
Thank you.
I have commented on this subject a number of times in the past, and I will be a little bit repetitive for the people listening who may not have heard from me before, but I specifically want to start with the procedures for reviewing accommodations in the State Bar's admission rules, which I believe to be not in compliance with the State Bar's Title II regulations. The State Bar's Office of General Counsel has responded to this argument with the recital, neither Title II nor its regulations dictates any particular process for receiving accommodation requests, any precise timeline for deciding on accommodation requests, any particular process for how such decisions should be reached, nor a requirement for how much explanation must be given about an accommodations decision to a qualified individual with a disability. Now, this is not legally correct in my opinion, but it does sum up the general categories of flaws in the admission rules pretty succinctly and efficiently, because the flaws really fall into each of these categories. The biggest problem is that the process does not give enough information to satisfy any legitimate concerns, and doesn't give what feedback it does give in a time frame that allows within a single examination cycle to engage in sort of the collaborative process that an earlier commenter referred to to decide what accommodations should be granted. And the result of that is it takes a lot of retakes to even get through enough iterations where you've volunteered what is allegedly missing and have received a decision based on all of the things that you didn't know to volunteer before. For me, this has meant that I needed 4 cycles to pass the bar exam, and at no point did I reach a decision on my accommodations that I believe allowed me equal access to the exam. The delay in passing the bar exam means that each time an applicant is spending enormous resources preparing for the exam unnecessarily, it means that they're losing employment opportunities while they don't have a license, but it means also that they have lifelong career impact for even when they do get a license, if they're able to surmount this, because the gap between graduation and licensure is looked at by employers in perpetuity and limits employment opportunities, as does the collateral effects, the amount of work experience, the fact that if you can't get the same opportunities earlier in your career, that means that you don't have the opportunities that will be expected later in your career. The the impact of this is lifelong, and the reliance interests applicants have in fair access to a chosen profession is huge, because they this is a huge part of professional and personal liberty to have the experiences of a chosen profession like everyone else, but also because by the time that they've reached this process, applicants have invested years of time and hundreds of thousands of dollars, usually in paid for by loans, pursuing the education that's required to even start the process. So the degree of burden that causes staff to not decide procedurally or substantially a just way on the accommodations petition is hugely mismatched in terms of how little it takes to get them to not accommodate something to the stakes for the applicant. And this is also illustrated by what is alleged to be undue burden as well. There is often denial of accommodations requested based on the fact that it will take some significant amount of staff time or logistical oversight to, or maybe some cost to achieve, but even what is alleged is nowhere near what the cost of not being able to access the license is to the applicant at that point. And there is a huge issue, more modern, that is coming up with the pandemic, where people who need to take the test remotely weren't allowed to during the pandemic, when it was allowed for everyone else because of their accommodations, even if their accommodations with increased burden could have been accommodated. And now that it's in person for everyone else, the State Bar has chosen to capitulate to an NCBE requirement that it violate the ADA by not even giving individualized consideration to requests for remote, even of the applicants that wouldn't have made test in person during the time where that was standard. And now I believe for this upcoming July, there is no mask mandate, and the State Bar has expressed that not only will it not entertain accommodations for remote testing, but it will also not entertain accommodations for requiring the proctors to wear masks for immunocompromised applicants, or that they requiring proctors to test negative for immunocompromised applicants. This in spite of an outbreak at the testing accommodation only site in Burlingame for the February 2022 exam, where it did have more a mask mandate and a vaccine mandate on paper, though that was not fully implemented with the proctors chosen. The implementation of accommodations that are improved is another big issue. In July 2018, and with respect to a monitor, October 2020, I didn't have full implementation of my approved accommodations. And I know that a lot of applicants have told me that theirs were not implemented by proctors on site. And I believe some of this has to do with the lack of modification to boilerplate instructions given to proctors to reflect what's in the testing accommodations letter, such that they're facially contradictory, and very little training to the proctors who are not doing this as their full-time career, who are just contractors, as to what takes precedence when. There's huge, and it comes down to their snap guess as to what the State Bar wants. And there's no individualized instructions that reflect what exam rules remain in effect and what ones would necessarily have to be modified for implementation of accommodations that have been approved.
Sorry,
yes.
we've gone over in the 5 minutes, but if you have a few more items to highlight, please do so. I just want to give you the heads up that we have more speakers. If you could just try wrapping it up soon, that would be very helpful.
Yes, I can try wrapping it up. Thank you. I wanted to wrap it up by saying that I've submitted detailed proposed admission rules that I feel would comply and give a more just process. I've sent them in the past. I plan to resend them today as for my suggestions for what should be improved on the procedural side of it, and that I offered a settlement of a lawsuit for no monetary recoverment as recently as this year for even just a subset of those in good faith adopted, and that was rejected. So I hope that this means that there's been a change of perspective, the fact that this accommodations forum is happening, but I really wanted to remind the State Bar of those proposed rule changes, and that had it decided my October 2020 accommodations just a few weeks earlier or agreed to, it could have saved itself a ton of resources responding to litigation. Thank you.
Thank you, Mr. Cohn. All right. Next, we have Deb. Deb, when you're ready, please let me know. We're going to unmute your mic. Are you there, Deb? Deb? Okay.
Deb, you've been unmuted.
All right, why don't we move on to the next commenter then, and we'll come back to Deb. You want to give them a cue or stay in there? Mia, are you there, Mia? We're going to unmute you. Mia?
Hello. Yes, I'm here. Can you hear me?
Yes, we can hear you. I'm about to set the timer, so please go ahead.
Hi, my name is Mia Magabro, and I am currently a part of the Provisional Licensure Lawyer Program, which I would like to say is amazing, and it's provided me a lot of hands-on learning that I never learned in law school. So I work for a bar prep company as well. And one of the functions of my job is that I actually sit and work with students with accommodations that have never taken the bar, that have either been denied or are not sure what additional stuff to provide. I sit with them sometimes for an hour and help them fill out their paperwork, and they struggle every single time. So I think, especially for first-time takers, they need further information. The student earlier that went to UCI, she made a litany of really amazing recommendations that I hope the community actually really takes advantage of all of those ideas. A couple other things that I wanted to touch on is, one is the environment when taking the actual bar exam. For people like myself who have high levels of anxiety and ADHD, I have an 80-point deviation of my ability to comprehend when I'm under stressful situations. I would like to offer a recommendation for an additional accommodation for students who have anxieties such as mine, to be able to take the exam either at home or remotely.
Mia, are you there? Okay, we may have lost that commenter or contact with the commenter. All right, I'm hoping you can call back, Mia. All right, we'll move then to Deb, but Mia, if you can hear us, please stay on the queue. We'll come back to you. In the meanwhile,
I think we got it fixed now.
Oh, we do. Okay, Mia, are you there?
No, that's Deb actually. Sorry.
Okay, Deb, then please start your comments.
Is Mia back? Do you want her first?
We're working on that. So why don't you start your comments and we'll come back to Mia.
Okay. I'm listening to these comments and I'm, boy, I hope you don't judge me badly for saying this. I'm listening to these and I'm really surprised to hear that so many people with severe and obvious disabilities are being forced to jump through these incredible hoops to prove their situation. Yet I participated in 100% online exam last July that many takers passed without even doing a scan of their test taking room or proving that they had no cheating materials present. I understand that it was an odd situation, but it's just a pretty shocking state of cognitive dissonance to hear what these people were put through and just and then witnessing how that examination went last year. So I mean, I hope they consider that when they're considering the accommodations. But I want to get on to the I'm one of those people who was subjected to the fully online test, and I'm being granted a free retake, and thank you so much. It does not, however, make up for the fact that I'm still not a licensed professional, despite the fact that I'm adequately trained in my field. I'm not really suffering a great deal of harm from this because I'm getting gainfully employed. And but hearing these other stories leaves me wishing that I'd taken more effort when this happened last July to enforce my rights. Because when we all benefit when a person insists on enforcing their rights, that helps others to enforce their rights too. So I'm rethinking my actions of the past, and I fully believe that I would have passed this test on review had I been able to finish it. I passed the multiple choice section, even with the older, higher score requirement. And I take the blame for not being barred now partially because after I found out that you accommodated others who couldn't finish their test by allowing them to immediately retake the portion they couldn't finish, I didn't even ask. That's quite a miss for somebody who's applying to join the most litigious profession in the world. So I do take that on myself. But meanwhile, getting to the process, this is a moot point for me during this testing because I'm submitting for a withdrawal because of economic hardship. But this is a blessing because I haven't received responses to my requests for information about how this test is going to work and whether we fix the specific technical problems that I informed you of in my letter to this committee. We need to fix this now for those who are taking it now, and we at least need to fix it by February. We're dealing with changing technology here, and you need input from people with disabilities to know how this changing technology it affects them so that you won't be excluding us from the profession. In my specific case, the reading window for the last essay exam was too small to see, and I couldn't see the actual test without blowing it up, scrolling back and forth to read each line. And I've asked, for this test, whether we'll receive paper copies, whether I can use a magnifying glass that with this specific setup that I had. And I haven't received any response in over a month. How can I submit an official request for accommodation when I'm not being informed of how I need to work out that accommodation? I'm not being too lazy to find out these facts by searching the site. I'm a legal researcher. I spend all day finding out where to find hard information. Entire teams of lawyers depend on me to figure these things out. This is just lack of collaboration and lack of communication, which doesn't, serve the general public or the people that are seeking to become lawyers. So I agree with the many who've spoken before me. This shouldn't be an adversarial process. The lawyers who review this information aren't suddenly going to, it's not going to diminish the sufficiency of the bar itself. I get this as a guild and you want to protect the strength of the organization. However, we need to balance the needs of the general population too. I didn't choose to become a lawyer on a whim. I'm doing so because there's a dearth of well-qualified attorneys in my particular field. And that's why there's lawyers that depend on me, and I need to finish this process. And I appreciate that we're having this forum. I hope it's the first change and the first step towards change and not the last. I like the rest of the people who've come today, I've invested hundreds of thousands of dollars in my education with the expectation that I will be able to enter this field once I've demonstrated my competency. And right now, the only thing that's standing in the way of that is the ability to demonstrate my competency. And also, this is a computer age. Like many, I'm in favor of the open book test with a higher standard. I personally don't need it because I don't have any problem with my memory, but I know there's a lot of people that do. There is no lawyer I know who still retains the information they needed to pass the bar. All this test proves is that people are capable of memorizing information, not that they're capable of competently using it. It's not a skill that's even needed in the information age. The whole test should really be like the performance test. I know it's a lot of work to reformulate this decades-old test, but it no longer represents the actual skills needed to practice the profession. A lawyer today needs to know how to find and distill information. They need to know how to apply this information to the precedents. They need to know how to rapidly adjust when precedents changed, as they did this week immensely. This is a huge change that we've all had. And they can find this information on demand and memorize it in the blink of an eye. It just, this doesn't mean that they don't know how to use the information. The current standard doesn't fit the general needs of the public either. There's no substantial nexus between this test and how a lawyer does their job today serving somebody. So it doesn't prove that this lawyer can competently do their job. Me personally, I'd be in favor of the lower standard and the memorization. I can do that. But I think that, I don't know, it just makes sense to me to actually change the process at this point, especially since so many other things are changing at the same time. And I'm hoping that as the technology changes, I'm convinced we're probably going to move to 100% online testing here pretty soon. It's just the practical solution to the way the world is changing. I'm hoping that while you're developing that test, that you'll work with us and have these meetings with us so that we can help you, those of us who are going it right now, with this input, so you can make it a really, really inclusive process so that we can all produce lawyers that can serve the public, which helps to serve the general purposes of California. But, that's it for me. And I really appreciate you having this meeting.
Thank you, Devin. Thank you so much for your suggestions and recommendations. All right, with that, I will move on to M. I will set the timer when you're available. Are you there, M? M?
Hi, can you hear me?
Yes, I can hear you.
Hey,
when you're ready, start the timer.
Yeah, I'll just be really brief and just want to echo everything everyone else has said. The process for securing accommodation is highly Byzantine, needs to be revamped, and puts the onus on primary care providers. I've had the same healthcare team since my condition was diagnosed in 2003. They're very adept at providing information to me. However, that was severely curtailed during the pandemic, and getting access to my medical records was very difficult. And the depth and breadth of information requested by the State Bar was highly intrusive, highly invasive. And if I'm honest, I don't believe that the bar is equipped from a data security and privacy standpoint to handle such HIPAA sensitive information, nor is it in a position to request such deeply invasive medical records. So as an additional point to that, I will say, I have written the New York Bar, passed the New York Bar. I've written the Ontario Bar and passed the Ontario Bar. And those processes for securing medical accommodation were straightforward, to the point, not invasive, required, a similar amount of physician assistance as far as filling out the forms. However, the burden of proof, I will say, is substantially higher in California, and I would say unjustifiably so, especially for people who have permanent disabilities. Providing proof of ongoing effect is frankly offensive, and unless you have a physician that is reviewing things, I don't believe that certain things that have clearly either no cure or a permanent effect, they should speak for themselves. And so I yield my time. Thank you.
Thank you. All right, let me just check now. Do we have any comments at any of our locations, whether San Francisco or Los Angeles?
LA here, still nobody in the conference room.
Okay, and San Francisco?
No members of the public are here.
All right, thank you. All right, with that, we'll move on to our Zoom numbers. So Ava, are you there? Ava H.
Yes, hi. This is Ava. Can you hear me?
Yes, we can hear you. So please start.
Okay, great. Thank you so much. And I I just wanted to tell you how much I appreciate the comments that were made. As a fellow veteran and also as a medical professional, I'm actually a state employee as well. I work for the medical board. I completely concur these with the concerns that were expressed. I have a visual disorder, including glaucoma and cataracts. So, but I have been fortunate in that to see something a little bit positive. The state bar has been very, very responsive, but yes, it was very, very rigorous. Even as a physician, I felt that it was very rigorous. But when I compare what I had to go through with what the other people that commented did, it was, I must say, I very much sympathize and agree that the medical review system for accommodations needs to be reformed. And I unless there is a physician in that specialty that has the ability to communicate their concerns with the patient and with the other doctors involved, I don't think a non-medical professional is qualified to deny and interrogate. And I mean this with respect to the HIPAA and the FERPA information that was communicated. And I also am a patient of the VA, so I know that the information is very much protected. At the state level, I think we do need to have a secure system to accommodate the medical privacy of patients. And I just concur, and I do agree that if the state bar is in any way critical of the medical information presented, then a medical provider is the only one that is qualified to make that determination. And I say that as someone who just took the first year law student exam. So I'm learning myself, and I appreciate the comments that were made. And if I could be of help in any way, I'm happy to do that as a fellow state employee. Thank you.
Thank you, Ava.
Thank you.
That then we will move to our next comment. Kanita, are you there, Kanita?
Yes, I'm here. Can you hear me?
Yes, we can hear you. You can start your comments.
Okay, thank you so much for this opportunity, and thank you so much to the other commenters. I truly appreciate all of them. I feel like we're all in this together. It's good to know that I'm not alone in this. So first, I would like to read my letter that I sent in response to my petition, my accommodations petition being denied. Because I feel like the person that responded to me did not fully, read my letter. So I'm hoping maybe it could be heard on this forum. So I'm gonna, take out identifying information and all of that, of course. So this is what I said. I'm writing this email to let me know that I completely disagree with the determination that my accommodations petition is considered incomplete, and that I had a sufficient amount of time to acquire and file the required documentation. I disagree because of the following reasons outlined below. First, I did not have a sufficient amount of time to acquire and file the required documentation. As detailed in my general request, which was a complaint against the representative I spoke to her on Thursday, May 12th, 2022, in which I asked about the process of reapplying for accommodations since mine were expiring. I specifically asked about what needed to be included, and she promised that she would get back to me on Monday, May 16th, 2022 to answer my questions. This phone call never came. I called numerous times and left voicemail messages with the number she left me, and my voicemails were never returned. I knew I was running out of time, so I made one last attempt to reach out on Tuesday, May 31st, 2022. And I was finally able to speak to a representative named Maria, who was very helpful. However, that was when I also learned that the final deadline for the testing accommodations petition was within 24 hours and more documentation would be needed. Maria advised that since I was pretty much out of time, the best I could do was use the letter that my psychiatrist wrote on my behalf,
last year when I withdrew from the July 2021 exam, since my diagnosis was mentioned and it would at least indicate that I have the same diagnosis. I was also advised to write a new personal narrative explaining why I still needed the requested accommodations, which I did. I was further advised to add whatever I could to paint the picture that I still needed accommodations, which I believe I do. I filed a complaint because if I had received my promised phone call back with the correct information on May 16th, 2022, I would have had a sufficient amount of time to acquire and file the required documentation. Unfortunately, I was not, and I was placed in the very distressing position that I am in now. I not only had to pay a late filing fee for my registration, I'm also faced with having to take the exam without accommodations, which is something that I've never had to do. Two, I was specifically told that my files would be considered complete and there was nothing else I needed to submit. On Wednesday, June 1st, 2022, I finally received a call back from the original person who promised me a call back. She did not want to acknowledge the fact that she waited over 2 weeks to get back to me. She did, however, mention that she received everything I submitted and that she still had access to my previous documentation from 2017 and that she would add those documents to my file and that my file was complete. I mentioned to her that when I was applying, the forms section was grayed out in my application, and I asked if I would need to fill out those forms as well. And she told me that I did not need to submit anything else and that my file would be considered complete with a sufficient amount of required documentation. If this was not told to me, I would have tried my best to go straight to my psychiatrist's office in person and try to get the documentation from her the same day. I've had accommodations since law school, and I know how important it is for me with my diagnosis of ADHD and anxiety to have accommodations. Therefore, I would have done everything in my power to make sure I did everything I could to get them back in order to take this exam. Three, my current diagnosis should be an exception to the deadline. I did my psychoeducational testing in early 2013 and have had accommodation all throughout law school and each time I took the bar exam. My diagnosis has not changed since then, as indicated in my letter from my doctor. I'm still under her care and still receiving treatment and medication. I wish my diagnosis was something that could simply go away, but it has not. I need my accommodations just as much now as I did back then in order for me to have a fair chance at passing this exam. I truly believe that I should not be deprived of my accommodations because of unreasonable delays and misinformation given to me by someone in the testing accommodations department. With all this being said, I'm desperately pleading that my decision regarding my accommodations be reconsidered. I'm trying to not put in identifying information. I literally cannot take this exam without accommodations. I would not stand a chance at all. As I previously mentioned, I know the importance of having my accommodations in place. Therefore, I would have allowed myself to get everything in on time. Everything that has led me up to the position I'm in now has been incredibly unfortunate and could have been avoided if I received proper communication from the person who promised it to me. Therefore, I'm pleading desperately from the bottom of my heart that my extraordinary circumstances be taken into consideration, and at the very least, I can have a chance to get the required documentation submitted. Thank you for your time and consideration. So after all of that, the response that I was given was that I applied too close to the deadline and early filing is encouraged. This brings me to my issue at hand. I'm going to try to wrap this up. So first, as an immediate repeater, we found out that we didn't pass on May 6th. So the earliest I could have called was the week of May 9th, which I did. And the deadline being June 1st, that does not serve anyone well because, as it's been mentioned, there's been staff shortages and all of that, and it takes a while for people to even get back to you. So that hard deadline of June 1st, that doesn't serve anyone well because it's hard to even get people to get back to you on time. So, and then my second issue is that certain accommodations, as previously mentioned, I'm not even sure it's something that's permanent. So I'm not even sure why it needs to expire in the first place because the diagnosis hasn't expired. So I'm not understanding why it should be sufficient enough to show that we're still being treated for the diagnosis. It's having us with accommodations, having to jump through all these, hurdles and, all these difficulties just to show what we're really going through. And my last issue is that the accommodations for the bar should match those of us that have had accommodations in law school. They should at least match our accommodations in law school, seeing that we succeeded in law school. You know, we need to be given the best chance to succeed on the bar. I understand in law school, I got double time. For the bar, I get time and a half. That's fine. I don't have an issue with that. But in law school, I wasn't allowed to be tested for more than 8 hours in one day. And for the bar, the first couple of times I took it, that wasn't an issue, but all of a sudden that was changed randomly, no reason given. And I've been suffering ever since then, specifically with the multiple choice section, because all of a sudden I have to take all 200 questions in one day, which is something I've never had to do before. It's severely impacted my performance because on the essays, I would have passed with flying colors, even with the old cut score. But for the MBE, my score is way low because the second 100 questions, I was very tired. My focus was completely gone and I suffered because of that. So I was going to put that in my new accommodations request, which I did. And, you know, knowing that I'm told that it's too late and there's nothing else I can do but try to use it on a future exam, that's not really feasible for me because I'd have to wait another year pretty much. And that's hard. I'm already experiencing financial difficulties and this can jeopardize my employment. So I'm not sure what could be done now. I know the deadline to appeal accommodations is in a couple of days and I still haven't heard anything back. So I'm really hoping that these comments are going to be taken seriously. I'm not sure if there's any hope for me right now, but I figured the least I can do is just let my concerns be heard. So thank you so much for your time.
Well, Kanita, thank you. Thank you for, sharing your experience. I just want to alert everyone, as you're sharing your experience with testing accommodations, what we want to do here today is really hear your recommendations and suggestions. And I gathered that from what you noted, Kanita, and that is you want to reduce the burden that's required for submitting paperwork, especially when you've submitted in the past.
Yes.
And also to ensure that our staff response is timely and that when somebody promises to call you back, that they do. So I gather that. But for anybody else who's also going to be making comments, I think as much as you want to share, you can, but we really want to get to the recommendations portion. We want to walk away from this meeting with a list of recommendations. So the more that we can do that, the better. But thank you so much for your time, Nita. And then what I'm going to do is open it up to, let me see. I think do we have a speaker either or anybody wishing to make comments in Los Angeles or in San Francisco?
LA here, yes, we do have one person who wants to make comment.
Okay, so we'll take that comment from Los Angeles and then also
Okay, I'll let them know.
before we continue with comments made by Zoom.
We're testing accommodations. Okay. He's actually asking if he can just observe for now and if he'll want to comment, if we can come back to him later.
Okay, we can do that. All right, thank you. I'll check up on the office later. All right, with that, then we will open it up to KMG. KMG, are you there?
Yes, can you hear me?
Yes, I can. I will start the time clock now. So please start.
Okay, I want to thank you for having this meeting. And I want to thank all the participants that have already gone ahead of me. We are pretty much all saying the same thing. I'm going to read a statement that I've already submitted to the state bar, but it was written primarily from one of the representatives of attorneys at work that has assisted me. I applied for disability-related testing accommodation. Oh, the other thing I wanted to say is I'm studying for the bar right now, and I have taken this bar exam more than 3 times without accommodations. And this is killing me not to be able to study right now and to talk about this and to hear that other people are having just as hard a time as I am without having accommodations. So you don't have accommodations, and then we're talking about accommodations and why it's hard to get accommodations, and we're all studying trying to get the bar exam again. So it's just mind-boggling to me, but I digress. I applied for disability-related testing accommodations for the February 2022 exam. In applying for testing accommodations, I submitted the state bar's required forms for my physical, psychological, and learning disabilities because there's no preference as to which one you can pick or that you have to pick one. So if you have more than one disability, you choose all of them. I also submitted voluminous documentation in support of my application for testing accommodations. Accompanying the required forms were the reports from my healthcare providers, which were supported my requests, as well as detailed narrative, which discuss my history of accommodations. In support of my request, I submitted my initial neuropsychological evaluation, a recent neuropsychological evaluation, law school transcripts, medical records for the 6 months prior to my request for accommodations, and information from my Social Security Disability Insurance eligibility. The administrative law judge for the state had determined that I was disabled, and I submitted that proof showing that I was disabled, showing that I was determined disabled, and still receiving benefits for that, including in-home supported services through the state, and that I had a caregiver helping me at home for my disabilities. And my disabilities are lupus, Sjogren's syndrome, fibromyalgia, I have ADHD and PTSD. All of this, all my doctors having also submitted everything and signing all the paperwork, all of that was not enough. My accommodations were denied. The only thing they were willing to give me graciously was 15 minutes of extra time and the ability to stand and stretch whenever I wanted to. I then appealed. They gave me 10 measly days to appeal, no time to contact an attorney to help me through the appeal, but 10 days to do the appeal. In denying my accommodation and appeal, this is what the state bar did. They failed to presume a covered disability and failed to grant the past testing accommodation I received on time exams in law school, which are high stakes exams of a similar character to the bar exam. They required further documentation to support my request for accommodations, even though documentation of past testing accommodations was provided. They failed to follow the reports by my qualified healthcare professionals and experts who have personal familiarity with me. They failed to provide reasonable opportunity to respond to requests for accommodations. They required extensive analysis of my disabilities in order to deny my request for accommodation. They utilized my history of academic success as a basis to deny my request for accommodations and required excessive, unreasonable, and intrusive documentation that were not reasonable, limited, and narrowly tailored. The continuing course of actions and inactions of the State Bar of California and their agents and employees are violations of my rights, including but not limited to the following: intentional and negligent infliction of emotional distress, and discrimination and denial of full and equal access on the basis of disability and perceived disability in violation of California Government Code Section 11135, Section 51, as well as federal, statutory, and constitutional law. As the result of the actions and inaction of the State Bar of California, I have experienced emotional distress and economic losses. I will be seeking monetary damages. This did not have to come to this. If they just followed the law and stayed consistent with every applicant, this never had to come to this, and no harm had to come to any applicant. Thank you very much.
All right, thank you. And Kimchi, so we're at time, and thank you. We could move on then to our next comment. Avery, Avery, are you there?
Yes, hello.
Yes, hello. I'm going to start your time, so you can start now.
Thank you for inviting recommendations today. I graduated from law school last year, and I took the July 21 exam and the February 22 exam, and unfortunately did not pass either. One of the issues I had with the July exam was that I was not granted accommodations, partially because, well, mostly because there was a computer error and my application got stuck sort of in limbo. And despite multiple calls and multiple conversations with the State Bar and accommodations employees, there seemed to be no understanding of what my error was. This went on for about 9 months before, in December, when I finally spoke to an employee who said, oh yeah, I could have fixed this in 2 minutes, and also said she spoke to me twice previously and she recalled our conversations. So my recommendation with that is that computer errors need to be fully understood and looked at, and not just sort of brush off the applicant, especially because I kept being told this error meant that I just hadn't submitted something when it was a full error, and the State Bar employee had to go through and fully delete my application. There was nothing I could do from my end. So I took the July exam without accommodations because I'd already paid for it. It was getting close to the exam. I don't know how to fully explain how many hours and how much time and energy I spent working on my accommodations, starting before I even started law school, to make sure that I had accommodations for the bar exam. I've had various disabilities since I was a child, and my disabilities unfortunately became worse around shortly after I graduated from undergrad. And trying to complete all of this for the application, and then trying to deal with the computer issues and trying to see if I could even get accommodations was extremely difficult. And doing it on top of everything in law school felt like a whole additional burden that the other students weren't facing. It affected my studying drastically, as someone else slightly referenced, because the amount of time that students are required to spend on this is astronomical. You can't study, and it's also this pressure because you don't know how you should be studying while you're waiting to hear from the State Bar, and whether or not you'll have accommodations. I didn't know whether I should be doing practice tests with full-time or with my actual time. And it was extremely difficult because there's the whole issue with how long the application is. And there was also the issue going into February with not knowing exactly what I should be asking for, because I'd never taken it in person before. And it wasn't clear until after I'd submitted the application that the February exam was going to have a Scantron portion. That I thought it was going to be on the computer because it was on the computer in July. And so making it clear exactly what each portion is going to require from a student and what will be available to the student. I didn't know I'd need a clock because they removed all the clocks from the hotel room I was in. And we we get the same time markers as the students without accommodations if you have extra time. So for the first 3/4 of the exam, I did not have a single time marker. And it would only be in the last bit that I'd have a time marker. And so that leaves the student, it makes it really hard to track where you are. I also want to echo what another student mentioned about the hours. When I got my actual schedule, I realized for the February exam, when I did have accommodations, I realized that there was the middle day, the second day, I think I was there. I arrived at the testing center at 7:45 a.m. and I left at 8 p.m. And I had to be back the next day at 7:45 a.m. Especially in LA, I was making sure I had enough time to get there with traffic and everything. And it was utterly exhausting. I could not think. And that left a third day where I was working on essays and PT, where I was still so exhausted from the day before. I also wanted to mention that I think there needs to be additional training for proctors who are working with students with accommodations. On the hotel room floor, all the doors were left open because of COVID. There was one main proctor who was overseeing all the other proctors who was standing right outside my door. The whole time, proctors were coming up and asking her questions that I could hear in my hotel room, and it was extremely distracting. Additionally, at one point, the proctor said something that was, opposite to what I thought, what my accommodations were, because she hadn't been trained properly. And then at one point, another proctor came in and, said, "Oh, you have to hurry out for lunch because you're running late," and just shuffled all my papers together. Which I understand, but she didn't even let me put them in the pile in order. Then there was the whole issue where when you have students with accommodations due to things like ADHD or PTSD, having a proctor constantly walk behind you, directly behind you, because it's a hotel room, is incredibly nerve-wracking and anxious and caused me extreme distraction. And when I asked her, because the proctor kept leaving the room to go to the bathroom and take breaks, which is mind-blowing, especially when the student is forced to sit there, but to have them keep walking back and forth behind you is ridiculous when they could have just sat on the other side. When I did suggest that to her, the rest of the time she was passive-aggressive and rude and kept asking if I needed anything else, because obviously I was asking such a terrible thing of her. So training proctors is a huge deal. I also want to echo what other people said about the highly intrusive and invasive medical records. Even I had to get some records from my parents, even though I'm in my 30s, because they had them. My high school straight out told me they destroyed my records 16 years ago. It was mind-blowing the amount of work I had to do. They told my friends that 200 pages was not enough information, and wrote a really rude letter to her about how she did not follow the instructions. And so I really think that needs to be rethought. It needs to be, all of this needs to be redone. And I graduated from law school. I've worked on medical records. I've worked in medical fields. I've worked in the legal field since I was 17. And I found this process of filling out the application difficult. It was extremely expensive. And I had to go to so many of my doctors and pay to get letters or pay to get information from them, pay for records. It is an extreme hurdle that no student should have to go through just to get what is required to be given to them by law, especially when considering that this is to enter the legal field.
So Avery, we've gone over in time. So I just, if I'll give you another minute or so to wrap it up. Are there any other suggestions or recommendations that you want to make as a result of this experiment?
Thank you for that. I appreciate it. I would recommend focusing more on summary letters from doctors, particularly if the student has their regular practitioners that they've been going to for years, and the doctor says this is what they need, then the state bar needs to believe the medical professionals. It should not be the burden on the student to provide hundreds of pages of medical records. It should not be on the student to have to, when you do the hurry up and wait thing, where student has to submit all of this and then doesn't hear back with enough time to get back to them or to fix something. There was also just, it really, the amount of work that students go through for this needs to be diminished, especially for students with accommodations, and especially because it's not even with accommodations, this is just making it accessible for students. It's not even making them on an equal footing with the rest of their peers, because we still have the disabilities that we're fighting through with the whole exam. I greatly appreciate you giving us this time to give these recommendations. I know that some of the issues I had were specific to myself, but I think also I've heard about these issues from students, from so many people who struggle to get through this application.
Thank you. Thank you.
Amy, I'd like to ask Avery a question, if that's all right. Avery, what do you think the most time-consuming part of the process was for you? Was it getting the medical documentation, right, reaching out to the doctors, going to the doctors? Was that the most time-consuming? Was it the state bar forms and the numerous forms that had to be filled out? If you had to point to one of the things that really sort of was the most time-consuming, what would that be?
I don't know that I could break it down like that. I know I spent a lot of time getting testing redone, because the testing I had done when I was younger wasn't sufficient. I spent 2 full days doing testing. With going through all my own records and finding what I needed took a lot of time. Contacting each doctor, getting letters from doctors, following up by email, giving the doctors, a lot of the doctors said they were unsure exactly what the state bar even wanted from them when I said I needed a letter. So finding samples or language that I could give them. I think in the first time I took it, I mean, I didn't get accommodations, but the amount of time I spent going back and forth with the State Bar's Office of Disabilities, and the fact that the tech office just kept referring me there, that was hours and hours and hours trying to sort out what was even going on with my online application. For people with ADHD, just opening the application and seeing all the steps in there and then having to go through each step is demoralizing and a lot. It took a lot of time just trying to go through the application itself, way more than a student without disabilities or a person without disabilities would spend on just a computer page. So it's hard to break down.
No, that was actually very helpful.
Yeah.
Thank you. Thank you so much, Avery. I really appreciate the input.
Thank you.
And I think before we move on to more comments via Zoom, I think we have a speaker either from Los Angeles or San Francisco.
LA here. We do have a speaker. Whenever you're ready, sir.
Okay. Greetings, everybody. My name is Omar Taylor, and I was admitted to practice law here in the state of California last year in May of 2021. That journey for me, however, began much, much earlier than that. I took the bar exam for the first time in July of 2012. And I took nearly every bar exam during that 9-year period, save for 1 or 2. So I've taken the bar exam more than 15 times. Each of those exams were taken with testing accommodations. And so I've been fortunate, I guess, to have a great deal of knowledge, a great deal of experience in taking the bar exam. under testing accommodation conditions. I started it in 2012, taking it in downtown LA at the California Mart. I've taken it in Culver City at the DoubleTree. I've taken it in Ontario at the hotel there. I've taken it in Culver City. I've taken it at home. And so I've taken it when the bar was 3 days. I've taken it when the bar was 2 days. I've taken the exam when the new testing, the new scoring, or the new cut score. And so I've really seen a broad scope of testing accommodations across different environments and how those different testing accommodations have been administered. I've taken it in group settings. I've taken it where I'm the only person in the room, where I've had my own proctor, where I've had to share a proctor. And so I promised myself if and when I ever pass the bar, that I will do everything in my power to give back to those who are still behind me. And so I don't have any particular statements or questions here, but rather I want to open myself up to be as a resource for the bar and for those taking it now to answer any questions. That's really it. I've seen where testing accommodations can both be a benefit and a detriment. You know, under the 3-day scheme, the benefit was the fact that we had at least I had time and a half. The other end of that sword was that my exam was 27 hours rather than 18. And there was a real fatigue and attrition that's associated with that as well, which oftentimes would work against test takers. I mean, I've had hundreds of conversations with peers and those who are also taking exams under various accommodations, whether it be double time, time and a half, or what may have you. And so I really think I have a unique insight, both as a test taker and now being on the other side as an attorney, regarding this. And so again, I just want to say I'm here to listen, and if I can answer any questions or be of any value moving forward, use me.
Wonderful, that's very helpful, thank you. And I know that you're at our Los Angeles office. You know, we part of our review of our process is to get stakeholders once we have products to give us feedback on potential changes and changes as they're being made. So perhaps if you could leave us your contact information, and you could be, someone who a stakeholder that gets to verify products, that would be very helpful.
Absolutely.
Thank you for offering your time and volunteering on this very important initiative. So thank you. I want to check now with San Francisco. Do we have anybody in the San Francisco office wishing to make a comment?
We do not.
All right. So I recognize a name of someone who's already made a comment. I'll come back to you. I want to make sure that we get to hear others that have been waiting their initial turn to make a comment. So I'll definitely come back. But we're going to move on to Matthew. Matthew, are you there? Matthew? Are you there? Matthew? Okay. We'll come back to Matthew. Let's move on to Cicely Dickerson. Are you there, Cicely?
Yes, I'm here. How are you today?
Doing well. Cicely, I'll start the timer. Please share.
I'm sorry, I came in kind of late, so I'm not sure how much time I have.
You have 5 minutes.
5 minutes.
Something beyond that, and that's allowable as well. So go ahead.
Okay. Okay. First, I'd like to say there needs to be, and I'm not sure if there is, but I wasn't told. I don't know where to get the information from, but there needs to be a training on how to navigate the applicant portal. That's been something that I've struggled with during my time with applying for the bar exam. Secondly, it's not just accommodations. I think it's the whole entire system. I took the bar exam for the second time in February of 2020, and I applied as an attorney applicant, but I wasn't aware that I would have to take the general bar, and I didn't find out that I had to take the general bar until maybe a month before the exam. So I had to switch my whole studying situation. That particular bar exam, I had proctored. I shared a proctor with another applicant. So we were both in the room at the same time. This proctor gave us times of when we were going to lunch, you know, when we were stopping, how many minutes we had left. She told us, you know, lunch was at such and such time. So that was cool. The next time I took it, I was in the room alone. My proctor didn't do that. So I was expecting the proctor to tell me when to go to lunch, you know, whatever, because we had a schedule, but I didn't bring my schedule with me because I was told we couldn't bring anything but the stuff that we could bring. So I didn't know my schedule off the top of my head. And I was expecting the proctor to tell me, you go to lunch at this time. Well, she didn't. She just, you know, I'm waiting for her to tell me to go to lunch because I had finished that particular part of the exam early. And she never told me. I was just sitting in the room for like an hour and a half to maybe 2 hours, waiting for her to come back to tell me to go to lunch. And I was like, why is she taking so long? And I missed lunch. So that was an extra stress on me when coming back from lunch. They allowed me to go to lunch and start the exam later, but it was an extra stress on me because all in my mind, I'm thinking, oh my God, they think I'm crazy. You know, I missed lunch. I should have said something sooner. And my focus wasn't completely on taking my exam. I'm trying to remember what happened the last time. I took the exam in July of 2021. A month before the exam, or maybe 2 weeks before the exam, I got an email saying I had applied for the general bar because of February 2020. I realized, okay, I need to apply for the general bar. So in July of 2021, I applied for the general bar. 2 weeks before the exam, I get an email saying, oh, we switched you to the attorney bar. And I'm like, what? I haven't been preparing, I've been preparing myself for this multiple choice exam. And, that might help me. I've been spending a lot of time. I hope they'll allow me to just take the general bar. Well, I called to find out if I could, and no one gave me an answer. The day before, I was actually on my way to the hotel on the Monday before the test was going to start. I get an email saying I've been switched back to the general bar. Well, by that time, I had stopped preparing myself for the multiple choice. And I also had an additional day to stay. So I didn't have a hotel accommodations for 3 days. I only had it for 2 days. All of that, makes for a stressful environment in trying to take the bar exam. And like others mentioned, you have proctors walking back and forth, while you're trying to take the exam, they're talking, whispering. It is distracting. So in this particular time, and then in addition to that, this particular time I applied to take the July 2022 bar exam, but it comes to find out that my accommodations expired. I had no idea. I didn't get a letter. I didn't get an email. It's not on the original letter that I received granting me accommodations that my accommodations would expire. So I paid for the exam, and immediately after I got the notification that it expired, I requested to withdraw from the exam, which was the very next day. And lo and behold, I lose $400 because I didn't know my accommodations had expired. And had I known, I would not have applied because I knew from a month earlier that I could not, see anyone to get testing done or assessments done in time enough to take this exam. So I just think you guys need to revamp your entire system, or give us training on how to navigate the applicant portal so that we can see what you see, because I don't know that offhand. I have to really, really dig in and search that applicant portal to find the answers that I need. So that's basically my gripe. And if you guys can improve on the applicant portal, communicating with us, when we apply, or give us some time, some grace period another grace period besides the general deadlines to have things done, or to, maybe withdraw and be able to get a full refund if we can't get what you need in time, because I just think it's unfair that I lost $400 and I wasn't notified that my accommodations had expired.
Thank you, Cicely.
You're welcome.
We're gonna move then we're gonna try a Matthew again. Matthew Hintman, are you there, Matthew?
Yeah, I'm there. Can you hear me? I
Yes.
tried unmuting.
Yes, okay, we can hear you now. I'm gonna start the timer, so please speak when you're ready.
Thank you for the time, and this has been a great opportunity for us to be able to voice concerns. And, what I'm taking away from this and what has been my personal experience has been there's a general attitude of us against them. And so that really presents an issue in terms of one with a disability to try and approach, because what happens is that all of these, when you have a disability, there's a stigma internally. You're always dealing with things I'm different, things take longer. My particular disability is dyslexia. So reading, and especially the bar exam, takes a lot longer because I need to process that information. But when applying for that application, it really was daunting. It was an expense of about over $5,000 just in dealing with the proper medical professional to substantiate my claim. Because when I was in elementary school and in high school, there was no Americans with Disability Act. That didn't come into being until around 1989, and I was well out of school by that time. The net effect is, I think that if maybe it's more training for those who handle this issue. Number one, proctors have been mentioned. Some of them, I don't know where you get them, but some of them are really, I want to say, the nadir of proctorship. To them, it's 2 days of let's have a conversation in the hallway, which, as someone else has mentioned, is quite distracting. And I don't know, that's, I want to say a management issue. But I think the key thing is that if somehow maybe those who handle these requests and process these are a little bit more buttoned up in terms of responding. That's been an issue that's been brought up, that, you make a phone call and it's like, well, you leave a message, it's in the land of lost phone calls. You don't get a return call, and you have to really pursue that person or pursue the bar to even get a response. So again, that's a personnel issue. I don't know how you handle that, but that's something, I know it's state employees, so it's a different ballgame. So, that's kind of like the gist. I think it's the whole demeanor of the bar. I understand part of that demeanor is derived from ferreting out those who may be charlatan. And, I get that. We get that. But we're dealing with something that we live with, an affliction. It's latent. It's not, something that is readily noticeable to most people. Especially when it's something like a visual discrimination disorder as dyslexia. There are others that are more patently obvious because you can see it. In this regard, these are things that, I don't know how I can further describe this, but it really makes one feel like, they're different. They're not on the same equivalent, that we're lacking in some regard. And it's like, no, we're not stupid, as someone else has also stated. We graduated from law school. We achieved a Juris Doctor, and from an accredited institution within the state of California. So, these are things that, it's kind of like, maybe there's a personnel issue, but, we're just turning around and it's kind of like, listen, I appreciate having an accommodation. I appreciate that, my disability was recognized and given some sort of credibility to attaining accommodation. But I understand that process was not without days of like scratching my head. What did I say to these people? What did I do wrong? And again, that's the us against them. I realize the bar exam is an exam for basically designed as an exam of exclusion. And so, knowing that going in, you have to take a proactive stance and be prepared. So this is where I'm coming from. And I appreciate, again, the ability to be able to either mirror some of the things that people have already brought up, as well as maybe give kind of an overview on maybe a way of remedying this is getting rid of some of the attitudes that come across in either correspondence or on the phone. So that's kind of my piece. I'm sorry, and I thank you for your time.
Matthew, if I can explore with you just a couple of questions about the us against them, and I appreciate you characterizing it that way. Did you experience this mostly in this feeling of us against them in oral communications? Do you feel that this was in the process that was set up in terms of the required documentation, that was sort of putting you on the defensive? I just want to sort of get a sense of the sort of different arenas in which, or the different ways in which this felt to you, this came across to you as an applicant, as you know, the State Bar really not there to help you resolve this problem.
Well, it came across in a variety of ways. I mean, even in correspondence, even in phone conversations, certain demeanors. I mean, you know, even with, you know, you walk in and the proctor's, well, here come the handicap, you know, I mean, that's kind of like what you get the feeling like that. And it's kind of like, well, wait a minute, you know, I'm no different than anybody else. And, you know, I may take longer to read, and that's because of things beyond my control. That does not mean I don't have the ability or the acumen to take that test and pass it. And given accommodations is great, but you know, part of it is the whole process is really, and I understand this is part of the ferreting out of those who, hey, this is a way of getting more time. Well, it's, you know, wait a minute, I need more time. I struggled through both elementary, my high school career, and in my college career, and even in law school. The amount of reading I had to do in law school was phenomenal. Yet with being raging dyslexic, it took me forever to get through the case books to be prepared for class. But in terms of your question as to what during the process, part of it, it's kind of like the whole deal. And, you know, there's a two-part component to it. Yes, the paperwork, I understand the paperwork. I understand the substantiation in terms of getting a credible physician or medical professional to substantiate your claim, especially when you're someone of my age who went through the academic process when there was no ADA. So now we're looking at the fact that how do you want to refine your process? Well, part of it is maybe training people on how to even deal with us on the phone. And maybe it's a special group within the bar that handles these types of issues, because some of them, I'm sorry, I mean, they literally have the finesse of a bull in a china closet when handling some of these questions or dealing with, you know, people such as myself. And, you know, again, I have been a victim of the unreturned phone call. I've been a victim of, you know, kind of like hostile responses in correspondence. And it's kind of uncalled for, again, unsigned by the mysterious bar employee, some phantom. So, I mean, these are things that I mean, it's a very stressful and emotional process that you go through to take the bar exam, preparing for it, the whole mental trauma that you're dealing with in terms of, am I going to do it this time, and all that anxiety, and it's only complicated. So you're dealing with a real kind of different kettle of fish than your generic law student or attorney who's taking the exam in another state. Am I making sense? I don't know if I fully answered your question.
You've definitely given me enough to go on with that. So I appreciate your taking the time to respond to the question and to present your testimony in the first place. Thank you, Matthew.
You're welcome. Thank you for hearing me.
Okay. With that, I'm going to check right now. If there are any comments in either the San Francisco or the Los Angeles office. Okay. With that, then we'll move on to Jeff. Jeff, are you there so you can share your comments?
I am here. Thank you.
Okay, welcome.
Hi. I've heard my fellow test takers, and I know I've listened to a very diplomatic answer, and I'm just going to say it out loud. It isn't us versus you. I've received several emails, some with your name, Ms. Nunez, on it, that were less than. And I don't know whether or not you were aware it was going out or if you meant it to come across this way, but very blunt, very matter of fact, very, so what are you going to do about it? I'm not going to go over my diagnosis and things like that, except to say this. I've been to separate physicians, a psychiatrist, a $2,000 evaluation. Prior to that, I had other evaluations all submitted according to the rules set by the state board, the State Bar of California, only to be denied by someone who never spoke to me, someone who never evaluated me. And what I can't understand is, how is it, and I heard another speaker say this, how is it that someone who has never evaluated any of us making a determination on whether our accommodation request is valid when board certified professionals are saying this party has this condition and this is what's needed to give them a fair playing field? What I have seen is a loss of money, both for me, and I've heard many people that have spoken before me say it. State Bar does not often return that money. When it's asked to be returned, we are giving flimsy answers. Because of a miscommunication from the State Bar, I applied one day late and was hit with a $200 late fee. And this is during COVID, when I could no longer go out and see my clients, so my funds were limited. Was any consideration or compassion given? No, none at all. So it seems like the bar is a faceless group that's dictatorial, that does whatever it wishes. And right now, I'm speaking for not only me, but 200 others that I've spoken to that want to start a lawsuit, a class action lawsuit for ADA violations. That's another story. My recommendations are these. The first one, adopt ADA guidelines in total. Use that as whenever you're sending out a request for information, make sure that it's something that the ADA is putting out specifically. Either that or work with the ADA closely to make sure that the bar is not violating their rules. Or get an ADA certified person on staff. My second recommendation is a return of the fees that were lost due to accommodations being denied. Because absent of some other, I don't know, document that this nameless, faceless doctor that none of us has ever seen, none of us know their credentials, overriding physicians that have treated us. I've suffered from some things since I was 13 years old, to come along now and say, well, you don't seem like you have the issue. My issue is this, and I will reveal one and I'll try to go faster. I suffer from something called misophonia, something that was not widely diagnosed until 1995. It is a combination of oral and mental issues. I hear things very loudly where other people may not be bothered by it. Certain noises will literally drive a person to terminate the source in extreme cases. Thank God I'm not that bad. But when I'm put in a room with 200 to 300 other people, and there's clicking, and there's coughing, and there's sneezing, and there's shuffling, and there's pencils tapping, and all these other things, it is the proverbial cat, long-tailed cat in a room full of rockers. My third recommendation is to provide a 10-day, automatic 10-day grace period for those who want to withdraw if their accommodations are denied, and that they be given a full refund. The reason I say this is because the state or the California bar is benefiting from this money, but we're not getting any benefit of it. I read the first time they were doing the online test taking that this is something that's been researched for years. So I don't understand why it's being presented as if it's something new, something that should not be done. My fourth recommendation is to eliminate the review of past performance. One's past performance does not dictate how they will perform in a particular situation. I have a high IQ. I do very well in all subjects, but put me in a wrong situation and all of that goes out of the window. One small example, it will take me 15 to 20 minutes to calm myself down when I'm put in a room with noises I cannot block out. So I'm already down 20 minutes. My fifth recommendation is no in-person tests. There's no benefit for it. None. This technology has been going all around the world for years, and I don't understand why the State Bar of California has not caught up. And the last one is be very specific. I was giving 3 different reasons for what was needed for my accommodation request. First, I was told a letter. I provided a letter. And it wasn't until I had to take the test a second time that I was told it was an evaluation. Then I was told that it was an evaluation of 20 plus pages. I'm out of pocket over $2,000 behind that. But has the State Bar returned any of that? No, they've benefited from it. And we've gotten nothing out of the bargain. That's all I have. Thank you.
Thank you. All right. Next we'll move on to Marquez Moses. Marquez, are you there?
Can you hear me?
Yes, we can hear you.
Okay, great. Thank you for the opportunity. I want to start off. Yes, my name is Moses Marquez Simone, and I benefited last June with accommodation. I appreciate that. I'm a success story in that way. But initially, I believe my accommodation was denied and later was approved. I did have a private room and a private proctor. I appreciate that. I did submit a letter of appreciation for my accommodation. Sorry, my voice is breaking up. But I have a different physical issue as I get older, and once again, I appreciate the accommodation was approved. Other than that, I'll just be short and sweet. It is a difficult process to get accommodation. You don't know if it's going to be approved or not, or going to work with alternatives to be in a room or sit at a chair and take care of yourself while you're being under the eye of the camera. So anyway, I'm sorry. Let me drink some water. Anyway, it's nice that we get in feedback from other people. Thank you. That's all I have.
Thank you, Mr. Marquez. So we've gone through 2 comments. Do we have any comments in either San Francisco that need to be made in public or in Los Angeles?
We have nothing in San Francisco.
Okay. All right. And, next we have John. John, are you there?
Yes, can you hear me?
Yes, we can. So please start when you can.
All right, thank you. I mean, a lot of people have shared a lot of what's gone on, so I kind of want to echo a lot. I'm someone who both my parents are blind. I'm blind in one eye and have had accommodations forever, and it took turning in all of the documents and everything that the bar asked for, but then they came back to, oh, well, you need something from your grade school. Well, my grade school, they delete stuff after you're 27 years old, and I'm like in my 40s already. So that stuff doesn't exist. So the bar's saying, oh, that's not good enough. We have to deny you for that. Get some report from your doctor. I turn in a report from the doctor and they say, oh, well, your doctor's not a California doctor. We need someone from a California doctor. Like, I don't go to a California doctor. What difference does that make? How is that an issue? And it just doesn't make sense. So with all of the evidence of accommodations, like many people have said, through law school, through undergrad, through my master's program, all of that, from doctors, no matter what state they're in, why is it that someone at the State Bar of California can say that these doctors and all these other reports aren't good enough? That doesn't make sense. Flash forward, it finally got approved. Then they gave us an extra accommodation that we didn't ask for. They gave an accommodation of being able to circle your answers on the books for the staff to then transfer it to the Scantron. The problem with that is because then they marked in there, okay, well, if you have any scratch outs or marks or anything else in the book, they're going to put those down too. So some staff person is going to take your circled answer plus a scratch out that you did and both put those on there, making sure that every answer has more than one marking, which guarantees someone failure. And the bar's reasoning was that, oh, that was designed to help us. That's designed to guarantee people to fail. So if somebody didn't ask for that, that's not something that was not a good option to come up with, whoever came up with that. And like the couple gentlemen ago said, they didn't, people didn't even take the time to ask us, talk to us about that. And I had to fight to get them to even remove that. And on one of the exams, like this person, whoever they did, they went and seemingly marked multiple answers for all of our multiple choice. And any one question with two answers is an automatic failure on that question. So if they do that through the whole test, that's guaranteed screwing people over, so to speak. So that kind of stuff needs to be evaluated some kind of way. That messes people up. That is not a helpful situation at
all. So John, the extra option that you're referring to, it was that extra option was to circle within the book and then have that I guess moved and filled out by staff onto a Scantron sheet.
Right. But then their documentation said, but then we weren't allowed to watch them do it. If we had any other scratch outs, they would also copy that into there. There was a lot that was, it's not conducive to having us in control of our own passing or not. We don't know. And unfortunately, like someone mentioned, some of these overzealous proctors, they're like, oh, there's a scratch out and there's a line, I'm going to put both. And that's what they were pretty much flat out telling us, that that's what they were going to do. And so that's messed up.
All right. And then, so what would your suggestion be in the alternative then?
Well, we didn't ask for that. Mm-hmm. That was never asked for. So why was that even an option that came up with out of the blue and keeps getting off? If someone asked for that, great, fantastic. But I didn't ask for that.
Mm-hmm. Well, then what would be your recommendation for the ideal method for completing the multiple choice?
If someone has issues with, like in my case, with visual issues, and if the Scantron is possibly, let that person fill it in. Or if you have to have a staff person help, we should be able to monitor that to point out. Because I don't know about you, but in tests, we scratch out, circle, underline stuff all the time. And you break it down, okay, it might be B and D. All right, I'm gonna scratch out C and A. And then, okay, but if this person is going to take our scratch outs and mark those also as answers on the Scantron, they shouldn't do that. That should not be a requirement. They should be like, hey, he scratched out these, but he obviously marked this one as the one he wants. Just put that one. They shouldn't copy our scratch outs also. It's a recipe for failure to put someone's scratch outs on there.
Okay, thank you. All right, thank you for sharing. All right, next, we have Nancy. Nancy, are you there?
Hi, I'm here.
Hi, okay, well, welcome, Nancy. I'll start the timer. Please start.
Thank you. So I too am a success story after 3 attempts. And I actually concur with most everything everybody has stated here. And my main issue was when you are already dealing with, personally, I have fibromyalgia, not diagnosed until a year after I graduated. And I've had 2 major back surgeries, so I have plates, rods, and screws in my neck and my lower back. But that doesn't affect my brain. So I actually passed law school and I got accommodations. But every day, every time that I had to work on those accommodations, it was demeaning. It felt demeaning. It felt belittling. And it felt humiliating because I was made to go through hoops that the average student didn't have to jump through. And so it seemed like it was double jeopardy. Damned if you do, damned if you don't. Either you follow the guidelines so you can go ahead and take the test and be on the same playing field, or you don't, you give up. So in filling out those forms and going through all the hoops, I pulled aside in my car and I've cried. Lord, am I really doing what your purpose is for my life? Because this is really hard. But I still managed to pull through, and after everything I've been through, I graduated in 2011, and I still took the bar and passed it this past February. So I'm very grateful for the accommodation. But that doesn't change the fact that while going through them, you really feel humiliated, like you're begging for something extra. But the reason we have accommodation is to help us play in a game that otherwise we would be marginalized from, because our issues, even though there's nothing wrong with our brain, tend to make it more difficult to play in that game. Accommodations evens it. But the next problem is, and to resolve that, I don't know how to resolve it. Honestly, I'm not going to sit here and make up a story on the fly. I don't know how to resolve that. But what I do know how to resolve, and I think that should be taken into consideration, is the humiliating part is when you go to the testing site and the rules were stated one way and they change them on the fly. They change them right there in front of you. And then you hear somebody next to you be given a simple accommodation that, oh, for example, a live example is, if you have not been vaccinated, then you must show a recent test, a test within the 48 hours or the 24 hours, yada, yada. So information is given to some people and not given to others. I found that very difficult to swallow. I couldn't wrap my head around it. And dealing with that kind of stress, that level of stress, the day before taking the bar really sets a person back. I managed to pass, and I can only say it has to do with my abilities and not because despite the stress that I was put under the day before the bar, I still passed. But what I'm saying is, and somebody mentioned, it wasn't Matthew, but I think it was, there were several people who actually stated it, that the attitudes of the proctors, the attitudes of those who sign us in, they are shitty. I am so sorry. I don't know what other word to use, but they are absolutely demeaning. We're already behind the 8 ball, but we have the gall. Yes, we have the gall to go to law school, and we show that we can because we passed. We graduated. So if you're supposed to be helping us, why in the world would you treat us like crap when we get there? All I'm asking is that the people who are the face of the California State Bar have decency when it comes to dealing with people with disabilities. I'm a go-getter. I am 58 years old. I have never sat down, and I've been injured for a long time, since I was 18. And I've done a whole lot of things from there to here. And the part that I have the most difficulty is when I'm dealing with people who haven't even walked a mile in my shoe, treating me like I'm crap just because I have a disability. Because I will walk circles around them if we have to go toe to toe in any situation. And so I'm just saying, if you guys, and I'm sorry, because the anger is coming back, even though I passed, the anger that I felt having been subjected to that kind of treatment was just, it's an injustice. So forgive me for my passionate, boisterous way of saying the things that I'm saying right now, but maybe some training in how the face of the California State Bar deals with people in person when they are actually going to take the bar, the day of and the day before. And lastly, with the accommodations, I heard somebody say, I also have ADHD, and I cannot deal with minutia. I get so irritated when I'm trying to do something and I hear, click, 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 because I can't get it out of my head. And so that's part of the reason why I had the accommodation. But when the proctors are talking and laughing and walking up and down and just, I literally had to yell after about an hour at a proctor. I literally, can you please shut up? I literally that loud. When I get to that point, I am so full of anxiety because I have been trying to do a test for an hour and I know I've lost time because I have to keep reading the sentence over and over and over again. The fact that I passed the bar tells you something, but why should I have to have gone through that? Why doesn't the proctors understand this is a very difficult test? And if we have accommodation, it's for a reason. Respect the rules. I can't run around laughing and joking. So I wouldn't expect them to, yet they did do it. And I took the test 3 times. And the last time was the worst. Praise God, I passed it. I still sometimes pinch myself. How did I do it under those conditions? I don't know, but I did. So long story short, that's what I can recommend. That they get some training on interpersonal skills when you're dealing with people who have disabilities, who are already frustrated, who are already under more pressure and stress, having to jump through all the hoops that an average law school student does not have to go through. So we're like double whammied. And I'm just asking for some consideration in that part.
And Nancy, as a follow-up question, you've offered suggestions about, some of the training that we could provide proctors or things to make efforts to reduce while at the site. But what about in the check-in process? Do you have recommendations around that?
So the check-in process, for the most part, was okay, but there was something that happened that was so ridiculous. This year, because of COVID, we had to have our test proof when we got there. But they required test proof just to go up to see the room the day before. Now, there's no one else there. You have on your mask, it's 2 people. You can walk 6 feet apart, but they refused to let me see the room until I went and found a place to do the rapid COVID test, which they accepted. I wouldn't have had a problem with that because I could have did a 24-hour rapid, or I could have did a rapid that morning, but I wasn't advised of that. There was nothing in the correspondence, in the curriculum, in the handout, nothing, not one iota. I only found out about it because another lady in front of me started talking about how she had the same issue, and she had called the bar, and the bar told her, well, just go take a rapid test right now. I wasn't given that information. I only knew that information because I heard her. In other words, the young man that was helping me sign in told me, well, if you don't get it, you can't take the bar. Do you know what that feels like after how much time you put in studying? And I don't know about other people, but I have to put in double time because of the ADHD. And because I have injuries that hurt my body if I sit too long. I literally have to get up, walk away, come back. That prolongs my studying time. So to lose all of that and have to start all over again 6 months down the line, it's demoralizing. And the young man said it's a test to eradicate those who really should not be trusted with other people's livelihood, other people's lives, finances, what have you. I agree that we need a test because we need to make sure that people are competent, because you do have other people's lives in your hands when you are litigating for them and advocating for them. However, when you have people, I'm gonna say like myself, like Matthew that I heard speak, I can tell that he is competent. Just his language, his the logical reasoning that he's using, the basis of his arguments, I can tell he's competent. To go through all the things that we have to go through that normal law school students don't have to go through, and then be treated like that by the people who you see when you walk up, hi, my name is Nancy, I'm registered to take the bar, and they begin to treat you in a way that just feels humiliating. It's just humiliating.
All right, thank you, Nancy.
You're welcome.
Let me just do a quick check. Do we have anybody in person, either Los Angeles or San Francisco?
We do not.
No comment in LA.
Okay. All right, so then let's move on to our next commenter. And again, I'm going to go to people who have not spoken yet, and I'll return to people who want to make a second comment once everybody's made their initial comments. So with that, I'll open it up to Morgan. Morgan, are you there? Morgan?
Hello, can you hear me?
Yes, we can hear you. So please start.
Okay, thank you for taking the time to listen to us. So I have a few recommendations. I think it would be helpful if you opened the application earlier. A lot of students don't think about what this process will be like until, it's their third year of law school and they're looking at the application and they don't realize all of the steps that are required. I also think there needs to be more transparency in the application process. I know you guys have a checklist of things that are required depending upon which disabilities you are applying under, but that checklist is very minimal and it doesn't really encompass all of the things you'll have to do. For example, a lot of people have been complaining about the records that are required. For example, like if you have an IEP from elementary school, yes, most of these people are probably going to be earliest 25, 26, but could be, 40 years old. And most schools only retain records for about 5 years after you graduate, and then they are destroyed. So that's a problem. Also, a lot of people don't have these records. They don't know how to get them. And then, so I think that's a big thing that I think, you could put on there. And if you opened up the application earlier, it can give people more time to get these records, or at least attempt to make a good faith effort to get them. And then in terms of all the different forms. So I know once you open up the form, for example, ADHD, it'll tell you, this must be completed by a clinical psychologist, psychiatrist, or neuropsychologist. But, you may not know that until you open it up. So, if you just have been diagnosed by your family medicine practitioner, that won't count. So then you have to find one of these people to do it. For specific learning disability form C, you also have a list of things. But when I was trying to find someone, a lot of people were saying, no, they won't do it on adults because typically they only test, kids are up to age, 18, some up to 22 for, adult transition programs. But it's very hard to find someone who is willing to do it, will do it, and doesn't cost a fortune. I got some quotes of $10,000. I had to take another job my third year of law school just to pay to get the test done. It also, you guys require that the evaluation be done within the last 5 years. That automatically means that, if you were tested and given a standard battery when you are a senior in high school, that's already going to be too old. And that would be the last time that it would have been done by a school or a licensed educational psychologist and paid for. So to get that done privately is incredibly costly and it's difficult to find. So I think if you could provide a resource list of, hey, these are some organizations, or here are some search tips or tools for, each of these different categories of how to find them, or free or low cost ways to find people who will do these forms for you. The other thing is that, online it says, it should take 60 days for your petition to be reviewed with a response. The first time I applied, I think I heard back 73 days later, which I submitted my application pretty early, knowing that it tends to take a long time. And then you had 10 days to appeal. That was during the pandemic, and I was required to get additional medical documents in March of 2020, which was very difficult to do and very scary at that time. But it's an incredible burden on people who have to run around to get more documentation and proof to prove something that they've had and had to deal with and advocate for themselves probably their whole lives. So to kind of maybe have more transparency, hey, it takes an average of 60 days. If you want to appeal, you have a 10-day window. But for example, when I appealed, they treated it as a new petition. So that was another 60 days. So you're getting closer and closer to the actual exam date, and you're not knowing whether your accommodations that you are requesting are going to be approved or not. which adds additional stress onto the applicant and makes it harder to know how to study because you don't know what testing conditions will be like. And that is something that the average, non-disabled or community does not have to deal with. So I think making it very clear, opening it up a lot earlier in, even if you opened up the application like beginning of your third year or whatever, so August or September for the July bar or anything to give more time so that people could gather all these documents. Because it took me about a year to get all of these things. I think I submitted close to 400 pages. In the letter I got back, they said they had, you didn't provide this, you didn't provide that. I provided it, but I don't think they actually took the time to look through it all. So then I submitted it again, which is fine, but it's very exhausting to have to do that. And then, for like the MPRE and like a lot of these things, if people don't know that they need to save all these records. So if you have some kind of like steps that you could provide at the beginning of your law school journey of like, hey, these are things you'll want to keep and hold on to. I had to track down like my ACT score, my SAT score, all of these things, and it takes a lot of time. So I think the more transparent you can be, the better it will be for the applicant, because then they can have more time to gather all of these records and then provide them. The other thing is I applied under, I think, 4 different categories: ADHD, psychological disability, specific learning disability, and physical disability. And some of those things like don't operate in a vacuum. So some of the responses I got back from, the committee were like, oh, they didn't understand something. And I'm like, it's hard to talk about any one of these disabilities alone. Like none of them operate independently. They're all interacting at the same time. So that makes it kind of hard. Like, I did my best to articulate it, but if you could provide a list or some kind of a how-to for the narrative of how you would like it done, what you would like it included. I know you give a little bit, but from some of the comments I got back, they were like, oh, well, did you fail the MPRE? And I'm like, yes, I did. I did fail it the first time. Like, wouldn't you guys know that or have any communication with the NCBE? And they were like, oh, okay, so you failed it the first time. So you do need these accommodations. And then I failed the bar the first time I took it. And when I applied, I had to apply again. And so thankfully I had copied all of my original forms. But if you don't, then you will have to go get these forms done because you guys like the originals. So just, having a note on there saying, hey, if you're, it's a best practice to keep a copy of all of these records in case you have to sit for the bar exam again or need them for any reason. And then a lot of your things are kind of like hard. So I can see why some people are frustrated because you'll say things on the forms like must be completed by a qualified professional. What does that mean? Like, we're all attorneys or trying to become attorneys. So more like specific guidelines would help of who is a qualified professional? Who does this need to be done by?
Okay. Well,
yes.
Sorry. Were you going to say something else? Sorry, didn't mean to interrupt you.
Oh, no, you're fine. Sorry, I'm talking a lot.
Okay. Yes. All right. So Morgan, a couple of things. I was just going to ask you for a clarification when you talked about opening the application period earlier. Were you referring to the TA or to the examination?
The TA.
Okay. Because I just want to clarify that the testing accommodation application is a separate process from the examination. So that's open year round, and you can, as you suggested, if somebody wanted to start in their third year to fill out an application for an exam in the upcoming year, that is currently feasible.
It's feasible, but not really. So if you open it up, because I opened it up in August or September, but it was allowing me to do that for the February bar.
Mhm.
See, so, and I wasn't going to sit for the February bar because I didn't graduate until May.
Mhm.
So then once that closes, then they open it up for sometime I think January or February is when they open it up for the July bar. So if you could maybe have an option to select, hey, I want to start this application earlier, but I'm not sitting for the February bar, I'm sitting for the July bar. I think that would help, because otherwise you have to re-enter in all of this information.
Okay, well, I think we just need to make that a little bit more explicit, because you could apply now for the July 2023 bar exam, even though the July 2023 bar exam is not, that application's not open. But Morgan, your point is simply that we need to dispel that more clearly, and we've noted that. So thank you.
Let me also ask Morgan, just as I'm thinking about our communications and the way we communicate with applicants, and the avenue of the California law schools in particular that we use to help us communicate and to provide opportunities for us to come on campus, either literally or virtually. I'm just sort of trying to think about sort of the different communication avenues. Did you go to a graduate from a California law school, Morgan, or an out-of-state law school?
Yeah, I graduated from UC Irvine.
Okay. Yeah, so I guess to me that makes some of the comments you've made more distressing, because I think we do have we have a good relationship with the law schools and an ability we meet with the law schools, with the registrars, we meet with the law school deans regularly, talk about information that we can share with the students. And so it feels to me like we've got to do a better job of that, even for the California law school students, so that that information on how to apply, when to apply, all of that can really be communicated better. I was, part of me was sort of hoping you were going to say you were from an out-of-state law school, because I know that's harder communication, and we can certainly do that through our website, and we need to review how we do that as well. But certainly this is eye-opening in terms of the information that you're hearing as a student at a California law school. So that's really helpful insight, and I appreciate it.
Thank you. Yeah, I would say that when I went to my disability service center at UC Irvine, so as a 1L, I'm just going to go back for a second. As a 1L, they said, we don't want to provide you with the accommodations that you were given in undergrad, because we don't think that the bar is going to give you those for the bar exam. And so I said, okay, well, these are what my disability requires in order for me to demonstrate my knowledge. And so I pushed back on them and got those, but had I not, it kind of sets you on a path for then being denied later. Because then if I would have said, okay, I will accept less in accommodations, then that will look to you guys like, hey, she didn't need all of those. And so that to me was really distressing and upsetting. The other thing is, when I went to them, what they did was they printed out the TA checklist, but that's all they did. And they filled out the law school verification form. When I asked, do you know of a licensed educational psychologist, or how can I get this done? She did not know anyone. I ended up actually sending her resources after I had gone through the process, because I had to learn a lot of information to get all of these things together. So it's kind of distressing when they are supposed to help us and we're kind of in the dark. So I do think there needs to be more communication with the law schools, and just some way to provide more resources, because as students with disabilities in law school, it's already very challenging, and we're already kind of looked differently than our peers. Like a lot of our peers think, oh, you know, they have a leg up, and really that's not the case. So it's just a very kind of gaslighting process.
Thank you, Morgan.
So we are going to have a scheduled break right now from 1 to 1:15. We're shifting staff, and so we are going to regroup at 1:15. So please, we have everybody in the queue now. We'll come back at 1:15 and continue with our discussion. So thank you, everyone.
Let's try that again. Thank you, everyone that has come back. I am going to start by calling on our in-person commenters, if we have any in LA.
We have no one here in LA.
Thank you. And do we have any in-person commenters in San Francisco?
No in-person commenters in SF.
Thank you very much. I am going to go back to our list then of the commenters on Zoom. I am going to skip the first two people, as I believe that they have had time to make comments. However, if we have time still at the end, after everyone's made their initial comment, I will come back to you. Having said all that, is Mary Beth on the line? And
can you hear me?
Mary Beth, we can hear you. Thank you very much. You have
excellent. So, okay, sorry, we're just coming back from break. I'm trying to get myself sat down and settled. I just want to start by saying that this testing accommodations process has been the hardest thing I have ever had to do in my life. As far as like, you know, I went obviously through community college, through state university, and then I went to law school. Most of who I've heard here today, I kind of joined late, but most of who I heard here today are people that are actually bar applicants. I was actually a first-year law student exam applicant. So for me, it was a little bit of a different experience, but it's exactly the same process as if I were to sit for the bar later on. As a disabled person, I've heard a lot of things that like I really resound with that kind of echoed my experience as well, as far as it being like burdensome, all of the minute records that they want. To give a little bit of background, I have attention deficit disorder. I was not diagnosed as a child, so I had no IEP. I had none of the back records that they had wanted. So I wasn't able to provide those. They wanted me to do this really big neuropsych exam that nobody would do for me because I'm not a child. So they were telling me basically, we can do it, but it's not really going to be helpful for you and your insurance won't pay for it. So it was going to be an extreme financial burden to have that exam done. And then I was even willing to provide my genetic testing that shows that I have the ADHD marker, like I genetically have it, and that was not acceptable. So, you know, it was very difficult. And I also have physical disabilities. So then some of the same accommodations I was asking for were like for both, like because I have a bad back, I have to get up and move. I can't just sit stationary for hours on end. And they even denied those. So because they wanted something saying that my condition would not change within 6 months and or something like that. And it was very burdensome. So the end result ended up being I couldn't continue in law school because I couldn't get the accommodations, and my first year was like useless. So if I want to go back to law school, I have to start all over again. But I definitely am hearing a lot of like other things that other people are saying that I can, you know, kind of identify with. It's been a rough road, and my wish would just be that I feel like this process happens kind of in a vacuum, and that there's like no personal interview with this process. It's like me submitting documents and then getting a response back saying, yes, we're going to approve you, or no, we're not. So my recommendation would be like, if you truly think somebody is trying to get an accommodation that they don't deserve, or that, you know, somebody's trying to beat the system, like maybe a personal interview process should be part of this, you know, so that, or if like, you know, it gets to a point where the doctor can't make a determination, like you invite the applicant to come personally in front of you to answer questions about their disability or how it's affected them. And I know that adds more on your end, but I feel like I could have explained some things in a way that documents alone wouldn't show. I mean, I'm not saying that I, just threw this application out there. I had 10 years worth of academic records that substantiated the disabilities and the accommodations that I got. And even those were not good enough for me to prove that I had ADHD because I didn't have that one single exam done. So, there's, like I said, I've heard a lot of things today that kind of mirror everything that I've experienced as far as the burdensome, the time consuming, the searching for the records, and then simply not having a way to explain that I don't have certain things because that's not how my life evolved. Like, I spent the first, K through 12, completely messed up because I didn't have anybody to advocate for me because I had learning disabilities and I didn't know. So I'm coming to, as an adult, I've corrected that, I fixed it, I've found solutions to my issues, and now I'm being told at the law school level that, you're not good enough, if you can't perform without these accommodations. Something that Morgan touched on before the break was that she was told by her Dean of Student Services that they didn't want to give her the accommodations because the bar would not likely give them to her. And I had that same experience and was also told by the Dean of Students that my academic abilities did not suit their program. And I was academically disqualified after one semester at an ABA law school. So that definitely does happen. They are discouraging people with disabilities at the law school level as well, because they don't feel the state bar is going to give accommodation.
Thank you very much for your comments. I am going to move now to Christian Park.
Yeah, hi, good afternoon. So I passed my first time. I'm a 2020 grad. I had accommodations through undergrad and through law school, as well as for the bar. I didn't apply for it for the MPRE, but I did pass my first time. However, I do want to note that applying for them was extremely stressful. It was a lot more in depth than I thought before I had to look into it. It cost me about $5,000 to get testing done to prove that I had ADHD, even though I was diagnosed with it when I was 13 or 14. And they wanted me to go far back as to having medical records of that. It was tough to even try and prove some of it because of the fact that my psychiatrist that I saw was no longer in business. There's just a lot of things that they want me to go as far back as possible, and just not feasible. And I consider myself as someone who doesn't like to procrastinate. So I like to look at things ahead of time and to keep and save stuff just in case. And even then it was tough to finding some documents that were needed or that the bar was requesting. I do feel, however, though, that I've seen from other applicants as well as friends as well who have been denied when, in my opinion, they shouldn't have. I believe the bar is overly rigorous in terms of granting accommodations. And I think that it should ease up on that a little bit in the fact that not everyone has all the documents that is currently what the bar requires. Some people were diagnosed with ADHD through trauma such as PTSD or anything else like that. And they weren't lucky like I was, where I was diagnosed early on and my parents actually took me to go see a doctor. I think it's really unfair, and especially the fact that when you appeal it, or the fact that you renew or try a petition for your accommodations again in the following year, you would get stuck with the same psychiatrist or psychologist that reviews your documents. I think that if say you apply for it again and you request the additional accommodations that you weren't granted, I think that it should go to someone else. I don't think it should be stuck with the same person. I don't think that's really right. And the fact that, of course, that same doctor is going to probably most likely make the same determination, because I doubt they're going to want to go back on what their initial determination was. I do take a big issue with, again, requiring some kind of testing accommodation, such as like the $5,000. I had to take out a student loan for that, just so I can meet the requirements for the ADHD for the bar. So that just added more to my student loans, even though I had documents from therapists, some psychiatrists, and psychologists. So even that just alone cost a lot. But I do think that it should be granted more often than it is. And in hearing to all these people here today, it's very troubling that these people's lives are being put on hold because they're not passing the bar, because they're not getting the accommodations that they need for their disabilities. And even though I passed the first time because I have my accommodations, I'm just here today taking time out of my work and just to speak on their behalf because I was lucky enough to be granted, and I feel it's unfair for these other people who haven't been. So that's all I want to say.
Thank you much for your feedback. I am going to move next to Taylor.
Hello, can you hear me?
Yes, we can. Thank you.
Hi, so my name is Taylor Israel, and I am the Director of Academic Success and Bar Preparation at Thomas Jefferson School of Law here in San Diego, California. I did submit written comment, and I'm not going to subject all of you to listening to everything that I wrote, but I did just want to highlight a few points, and I do apologize as I have been in and out of the meeting today, so I don't want to be too repetitive for what may have been said that I missed. But there were just a few points that I wanted to highlight, and I did want to share a voice of someone who is working with the school and has been in this world for over a decade, rather than a personal narrative, which I believe is majority of what has been heard today from when I have been in and out between student meetings with bar studiers. But as I said, I've been working with students for over a decade in various capacities as they prepare for the test. And there has been a sharp increase in applicants over the past few years who have been denied accommodations for the bar exam in what I've experienced, both with students or applicants that have graduated from my school, but also applicants that I happen to work with in a private capacity. And what has also been frustrating in a advisor role is we're trying our best to advise our students to, submit these applications as soon as possible, really work with them with the information that they need to provide, which are so many layers of details and testing and this, that, and the other, to make sure that it is valid, and they're going without a response until what feels like the last minute to them. I have students or applicants that I've worked with that submitted in January or February and did not receive a response until almost a week ago, and are finding out that suddenly the accommodation that they received throughout elementary, high school, undergraduate, LSAT, MPRE has suddenly been denied, or they're being told that even though a doctor and every other testing agency has said that they need time and a half in order to have a fair and equitable attempt at taking this test, suddenly the bar has decided that time and a third should be sufficient. Many of the applicants I've worked with have been told the feedback and have come to me and said that they feel that the tone in what is being written is rude or condescending, that they feel that their doctors' expertise, the doctors who have worked with them, the doctors that have advised them, the doctors that have examined them, are being described as insufficient, or the results are being viewed as incomplete or biased because it is confirming a lifelong diagnosis. So this new test must be biased because it was simply there to confirm the diagnosis rather than confirming a chronic diagnosis that is not going anywhere. Many of these have been viewed to be as cost-saving measures and put in place to keep a test within 2 days instead of 4 days, which the focus of accommodations should be to put these test takers on a even playing field with neurotypical, non-physically disabled test takers. And instead, they feel like they're forced to jump through extra hoops and extra fights and extra distractions when they should just be studying and doing practice exams, same as the next person. I, in my written comments, did detail a few narratives over the past years, including one that I do in particular want to highlight, which was a student that I worked with who was a disabled veteran. And, you know, she received her disabilities in combat, as well as psychological trauma during that time that resulted in various diagnoses that affected her physical ability and her mental processing, including a PTSD diagnosis. And because this was something that happened during COVID and she didn't have something dated by the right date or the right form, these well-documented disabilities that are sufficient to get payment from the government, that are sufficient to lead to her discharge from service, that were sufficient for a master's program, sufficient for the LSAT, sufficient for the NCBE, providing accommodations on the MPRE, we're suddenly told that they didn't exist, they were insufficient. And she was only granted her accommodations once a state senator got involved to fight on the behalf of a disabled veteran. It shouldn't be coming to this point. This should simply be a process to put these students on the equal playing field. And I hope that, be it a review process that is changed, where it's a secondary source reviewing the application and appeal, be it an interview, something can be done to help these students have that fair and equitable testing that they deserve. I've attended meetings with the California Bar as a viewer to hear what is trying to be done across the California Bar, across the first year law student exam. I've participated on committees with the first year law student exam. I know that there is so much work and effort being going in to remove bias, to remove these barriers to the entrance of law in order to have a more diverse profession. This accommodations process as it currently exists is a major barrier for these applicants who are not neurotypical, for these applicants who have physical disabilities, and simply something in this process has gotten broken in these past few years and needs to change. I appreciate the forum and the chance to say this, and I thank you for your time.
Thank you. We appreciate the comments. I am going to move to Kissy next.
Hello.
Hi there, we can hear you. Thank you.
Hi, my name is Kissy Martinez. My case is a bit different. I am an applicant who does not have a long medical history. Unfortunately, my child was murdered 2 years ago. And as I'm entering my second year of law school, I was not aware that I had the need. I was recommended by a few of my professors to talk to the disability department in school, which I did. And they asked for doctor's information because I was being, obviously, as many of you can imagine, it's very tragic. And I was being seen by a psychiatrist, by a plethora of doctors to deal with what was happening to me. I get the accommodations. So as I'm applying for the bar, I was told that I should also apply for accommodations in the bar. I follow all the instructions that was required, but the fact that my diagnosis, without getting into too much detail of what I was diagnosed with PTSD and an extension to all of that, including anxiety. You know, because of the newness of the diagnosis, the information I was required to gather did not seem like a lot. Yet I work with my psychiatrist based on the recommendations of the bar in the application. He also actually called to find out what else he can provide to support what they were asking for. And so he provided what he believed was necessary. This took quite some time. So I submitted my application the day before the due date. I get a notice a few days back, and the notice says the form is incomplete. It was a very generic notice with 2 bullet points on it. So I asked for additional information as to why it was incomplete. And I literally got a response saying, please review the letter we sent you, even though I had addressed the fact that I didn't understand what they were asking for, as it was a very generic answer. And I say generic because many of my classmates who have also requested for accommodations got the same exact response, even though we all have very different issues. Now, I'm not quite sure if any recommendations outside of the fact that once the application is submitted, there should be some time, even if it's close to the deadline, to complete if there's anything missing. Because the fact that my application was not denied, it was received as incomplete. There's no appeal process. And even if there was an appeal process, we are so close to bar date that it's just not feasible. And also the fact that now I get my accommodations denied, I could withdraw, but then I don't get no reimbursement of my application. It's just, this has been very messy. I've been fortunate not to have to deal with learning disabilities, as I was growing up. But now that I had to, because of my PTSD and my anxiety, I've now had to deal with this. It has become so cumbersome. And as I've heard so many people speak, they've had to deal with so much more than I have. And the response from the people that are denying or are reviewing the applications are so bland. And so it seemed kind of robotic, as if they were going through some check mark and some list that had check marks and something was not met, but they couldn't really look into it or explain why it wasn't met. And then it was just denied, return, incomplete, or whatever it was. That's it.
Thank you very much for those comments. I want to check with both of our on-site locations, Los Angeles and or San Francisco. Does anybody have some in-person comments?
LA here, we don't have any members of the public right now.
Same in San Francisco.
Thank you. I also only see hands raised on the Zoom platform for those people that have already spoken. If there are no more new comments, and I just got one, I was going to go back. Let's go ahead and promote Jay, and then we can come back to Deb and Michaela.
Hi, am I heard?
Yes, you are.
Okay. I kind of concur with a lot of the people that have had complaints regarding the whole process and filling out the information for the testing accommodations. The whole process that I've dealt with has been convoluted, dealing with people that are condescending, and it just seems like they're just not really trying to help. And to start off, like the tone of the whole environment was set this morning where, this meeting did not start on time. It was supposed to start at 10 and it didn't. Not to mention, we were all put on mute and we had children in the background making noise and everything. The first speaker, I didn't even get all the information because I could not hear. But that is the tone that they set regarding our concerns. And this isn't a forum where it's, a question and answer. So I'm just wondering, how much is this going to be really dealt with, or how much is just a pacifier to say we heard you and, it's just down the hopper? It's just really, really, you know, disenchanting dealing with this whole process. Secondly, I'm just really shocked that there are just so many non-medical providers overriding doctors' decisions. This makes no sense. You get a rejection letter, you know, by the committee of bar examiners. You don't know who's rejecting. You don't know who the doctor is that is actually, you know, overriding a doctor. This would never hold up in court. I can't imagine a doctor testifying and then you're gonna put up some, you know, administrator says, well, hey, according to my flow chart, you know, this should not happen. That's what's happening to us. We are getting denied by non-medical professionals. If there are medical professionals, nobody's signing off on it. This makes no sense. Lastly, well, no, I'm not even going to say lastly. The next thing I got a problem with is that this stuff is not done timely. It is not done timely. Right now, my stuff has been in the hopper going back since the first denial of the February exam. And so then they asked for the information again. We sent it again. My situation is I'm, you know, diabetic situation where I cannot see and it's not getting better. I get eye injections every month. It is not something you want to have to go through. And it's a situation where eventually I will go blind, but I just have to deal with that. And I can't even get any answers. Right now, I know they're sitting on my information going back to May. And right now, I have no answer of accommodations. I don't know if I need to set up to go to Anaheim to take the exam or if it's going to be somewhere in LA. I have to stay in a hotel. But right now, it's 27 days to this July exam, and I have no damn answer. And it's been over a month and a half. This is not acceptable. But yet they find it so easy to just deny us. I don't know what the process is. It is a phantom. It is, you know, a black hole of the whole thing. I sent the information twice. When I had to get it from my doctor the second time, I'm told, who is reading this? They're not reading. I didn't sent this before. And it's almost like a, you know, like I said, a flow chart where it's like, okay, to stall, we don't have all the information. And then my doctor sending the information again. Okay, well, let's just send some MRIs of the damn eye. Maybe that will help because they're not reading the information. And if there were doctors reading the information, they would already know the answers. But right now, it's just sitting there. And then eventually, I just can't help but wonder how many of us are going to get denials on the same date. It's as if it's just being put in a bin for rejection, and then it's going to be rubber stamped with some excuse. As I sit right now, I don't know where am I supposed to go. I don't know if I'm going to be approved, and this is not anything new. I got a rejection coming from the February bar because they sat on the information, and then during the Christmas break, when my eye doctor is on vacation, I got to try to get additional information that was not in the original process. Why do they do that? You fill out all the information and then they look at it and say, oh, well, let's just really see if something's happening. We want to get additional information. And so when he comes back in town, he fills out the information and then lo and behold, it's past the deadline. And there's nothing many of us can do. And you know that's a rubber stamp as far as a denial. This whole process is like a January 6th hearing. If you're not going to do something to actually change this stuff, I just wish they'd be honest and quit just sticking a pacifier in our mouth as if we're being heard. Like I said, we didn't start on time. I had things to do. And definitely I didn't hear the first speaker at 10 o'clock because of children all in the background. That's just how serious, in my opinion, and some other people had said that they're just not taking our concerns seriously. And it looks like a money grab from the outside. It really does. We are not the typical law students, most of us that are going through this process. We are 30, 40, 50 years old. We're not living with our mommies and daddies where we can sit at home and have everything paid for. This has been going on for decades, according to my uncle, who is an attorney. This is not new. And so it's like you guys are bad adjusters where we're paying into this, hoping that they will actually, help us to go through the process. And all they're trying to do is get information to just hurry up and give a denial. And like some other people were saying, for us to pay so much into this, and then you just get these rubber stamp denials with little information, zero transparency. It just makes no sense. And we're just out of money. So I got denied in February. Can't see half the damn exam. I just do what? Pray and just jump into it. And of course, we know the results because I'm still here. And they still have that same information. And here I am, 27 days to the next exam, and I don't even have an answer as to what's happening and where am I supposed to go to take this exam. And then when they do respond, we have little to no time, and they know this. I refuse to believe they don't know that the window to object, to get your doctor to send information, within 10 days, you give me a doctor that's going to write a report within 10 days as if you get it. They have their own schedules too. But yet that's what we're up against. And then if we don't get it in time, rubber stamp, not in timely. And we can't even start this damn meeting on time. But that's just the kind of stuff we have to go through. There's always been a biasness ever since they had part-time law students against us. You heard too many people saying how condescending they are towards us. We're not your typical student. Some may have a change in careers. Some may actually, for whatever the reason, decided to take this route to add on to their additional, profession. But it is a clear biasness. It's costing us a lot of money. We're paying into it. And like I said, how can you have a non-professional override a professional? It wouldn't last in civil court. There's penalties if you do that crap in workers' comp. You're going to have some adjusters show up and make a medical decision. That's a transparency I want to have done and change. Who is making these medical decisions against our doctors? And I'm sorry if I'm irate or whatever you may want to label me, but this is costing us a lot of money. And unfortunately, this is something ongoing. Ever since California started, part-time students, I've gotten information on all of this. Right, we're not your typical. And you guys know most of us, like I said, 30, 40, 50 years old or older. And unfortunately, we are not at that 20-something health. And here I am in a situation going blind, and I can't even get a damn answer. And they've had the information sent twice. And it's still pending. Pending what? Looking for a loophole for the last minute to sit up here and say, hey, we need to have something else. My doctor was kind of frustrated because they got to write these things again and again. And it's like nobody, like I said, he charged me. Who's reading this information? Because in this profession, it makes no sense that somebody doesn't understand. And then you just get these rubber stamp denials. Committee of bar examiners. Like in any trial or any situation in court, I would like to have the transparency of the doctors or the medical profession sign off on our stuff, or the nurse practitioner, or whoever is overriding our doctors. This is ridiculous. Like I said, you got people with flow charts, checking boxes and deny, stall and deny. Like I said, a month and a half you've had my information. I have no answer. I'm not even sure where I have to go. I've already paid for a hotel. I don't even know if I got to pay for another one. I don't know. 27 days to the exam. This is unacceptable.
Jay, I want to thank you for your comments and just ask you, since you're over the 5 minutes, if you have any just final remarks.
Excuse me, I'm sorry.
I was just letting you know that you're over the 5 minute and just wanted to ask if you can sum it up or if you had any final remarks.
Well, if anything, I would just like to have the transparency of these physicians or even non-physicians sign off, whoever are signing off, denying or overriding our physicians' requests. That's what I want, because it's not right, it's not fair, and it's falling into the biasness of your non-traditional law student. Thank you.
Thank you for your comments. As mentioned earlier, I am going to go ahead and skip over those people that have already had the chance to make some public comments and go over to, I believe, Mark, who has not had the chance to make a comment yet.
Yeah.
Mark, we heard you for a moment and then you disappeared.
Yes. Can you hear me now?
Yes, we can. Thank you very much. You have 5 minutes.
Yes. The first question I'm concerned about is whether or not if this is going to be posted online or the CalBAR website for those that cannot, stay for the entire meeting. And my second question is, are applicants going to get notification with respect to whether or not their accommodations have been modified or going to be modified in the near future if they're not successful on this upcoming July bar exam? Thanks for your help.
I'm not really sure if we're taking questions, but will this be posted online? I believe so. I believe all of these recorded videos are posted back on the State Bar website within a certain time period. Okay, having, it looks like no other new comments. I will go back at this point to Deb. Deb, would you like to make another comment?
Hi, yeah, I just wanted to enter a little correction into the record, if that's okay. I said at the beginning of my last comment that I can't believe you let the test takers pass the June bar exam without even checking their rooms for cheating materials. But people under the protection of the ADA are being subjected to this immense burden of proof for obvious disabilities. That wasn't meant to disparage anybody that passed the bar in 2022 June. It was meant to say that I believe that your burdens and the burdens that you're requiring from students are disproportionately applied to the disadvantage of test takers that are under the protection of the ADA. And that's just proof of one of the difficulties that we've been experiencing. And it's one of the proofs of the different experience that we've had from people without disabilities taking the test. But beyond that, I've been taking notes for this whole meeting, and I see that we have some problems that would be solved by, honestly, by changing this testing format. I'm thinking more, and I hope you don't do it before I take the test, because I've been studying for the other format and I'm pretty confident in my ability to pass the other format. But if you move to this open book testing format, or even an optional format for that, I wouldn't do it as an untimed test. And I'm one of the people that needs extra time, and I still don't agree with doing it untimed, because anybody who is demonstrating skills in this field needs to be able to demonstrate that they can complete those skills in a reasonable amount of time. But moving to a different format that maybe uses the internet or some sort of open book protocols or something would allow you to give this test online, which solves the problem with travel. It solves the problem for the immune compromised, because they would no longer have to risk their lives in order to take the test. It would allow those who can't accommodate the immune compromised to also take the test, because you have two diametrically opposed problems there. The screen recorders could be utilized so that those with visual disabilities like myself could use a larger monitor. I actually use a 50-inch monitor at home, so taking the test on a laptop screen is nearly impossible. But also with writing, I blow everything up because I'm having trouble saying, because, well, I'm old. And this would also help people with those memory recall based disabilities that can still demonstrate real world skills as transactional lawyers, but it's not as necessary to show those memory abilities anymore. It would dramatically cut your costs for administering this test, because you would not have to hire in-person proctors anymore. And it would allow for us to accommodate the changing environmental circumstances, because we know that it's becoming more difficult to travel now whatever the cause of those difficulties. Everybody has their own political opinions, but that does not change the reality that travel is becoming nearly impossible for some people now. And, adapting this testing format would allow the new lawyers to show that the newer skills and abilities that are required for us. So I think that this is something that, looking at this lawsuit that you're dealing with and all the other difficulties that we've been dealing with as a group, trying to adjust to a changing world, I think that considering changing the testing format would be a huge boon for solving this. It's a double, it solves like so many problems at once. And this is the perfect solution. It's the perfect time to do it. And you can set the standard for the rest of the nation. Like, one of these associations is going to have to start. And because the current situation, it's untenable. We can't keep doing it this way. So why shouldn't it be the California bar? We set standards and precedents for the rest of the nation all the time because we're good at it. So, and finally, when you choose this format, I hope we all do it together in this collaborative way so that we can find fastest, most expedient solutions and show the nation how it's done. Let's move this forward. That's the rest of my comment. And thank you for having this meeting.
Thank you. I am going to move to Nicolelle for your second comment.
Can you hear me?
Yes, we can. Thank you very much.
Thank you. I also have a question just because of the amount of contradicting information from folks that have spoke, which is that who does evaluate the accommodation application?
Sorry, as I mentioned before, I'm not really sure where this is. We're opening this up to a question and answer. Are there comments that you would like to make as opposed to questions?
Okay, so that is something that is not transparent within the process. So I guess that would be one comment. And then the other, if you're not answering questions, I do want to point out that some folks have mentioned starting very early on accommodations testing. But according to the website, I thought that applications were only open in March for the July and that you couldn't submit an accommodation request for an upcoming exam if you hadn't already applied to take the exam. So I'm a little bit confused on which or what of that is then correct. Maybe then my comment would be to be explicit on the website, because everywhere that it's hyperlinked for upcoming deadlines, it is only related to the overall application deadline. I think that the lack of transparency, even in this meeting, is really atrocious. It is really discouraging. I've been disabled and diagnosed since I was 8, and again, have not had to have comprehensive evaluation because these kinds of things don't just go away. There's no magical cure to a lot of this. And the lack of recognition from the bar on this is difficult. I believe that one of the things is that you have to have things within the last 5 years, documentation completed within the last 5 years. I think that that's a burden that's unnecessary. But I really am just fully disappointed by this lack of transparency. And I don't know that this, I know that it's called an input forum, but there's, and I can't ask any questions. I don't know how to not ask questions. I have so many, but I'm just wondering and hoping, I guess, that the bar will take these comments and say something before the July bar. Out of my school, I already now know of 10 other people, again, who received the same email that both Kissy Martinez, and I do want to say, because nobody else said it, Kissy, I'm so sorry for your loss. That's something nobody should have to go through, and you shouldn't have to go through and prove what that loss means to you and how it impacts you to any institution. I think that should speak for itself. And the bar has to be more clear on what it is looking for, because we have no idea how to meet those bars, those requests, and they keep moving. Oh, you need more documentation. Well, what are the magic words I need to tell you, right? You want, how many doctors do you need it from? And if you tell me that, I can do that for you, but I can't do anything if I don't know what to do. And that is unacceptable.
Thank you, Michaela, for your second comments. I am going to move on to actually Alan Shea, because I don't believe that he has had the opportunity to make his first round of comments yet. Alan, can you hear us? Alan, we can hear you, but it sounds very funny. I'm going to go ahead and say, why don't you try calling back in? Thank you. While we wait for Alan to come back in, I'm quickly scanning my notes to see if Melissa has spoken before. I don't believe Melissa had the opportunity to speak, so I am going to go to Melissa. Melissa, would you like to make some comments?
Hi, yes, can you hear me?
Yes, we can. Thank you, Melissa. You have 5 minutes.
Great, I'll go ahead and read my statement. The accommodations process is fundamentally flawed because it fails to provide transparency as to the qualifications of the quote consultants who are responsible for assessing my disabilities and determining which accommodations are necessary. It is important to note that my request for accommodations included reports and letters from 3 PhD qualified professionals who oversee my care: a neuropsychologist, a psychologist, and a psychiatrist. Their names and qualifications were clearly identified in my application. In contrast, the denial of my accommodations included excerpts of a report from unidentified consultants whose names and qualifications were not provided. The basis for my denial by the consultants included the following: 1, commentary that was in direct contrast to the plain language of the DSM-5, also known as the Diagnostic and Statistical Manual of Mental Disorders 5th edition, which is issued by the APA. 2, the consultant's report called into question my use of psychiatric medications as prescribed by a psychiatrist, commenting that the use of the medication was preventing my remission. In layman's terms, the consultants implied that the use of my psychiatric medication was preventing me from getting better. And 3, the consultants questioned whether my psychiatric symptoms were the result of a diagnosed psychiatric disorder or if I was simply experiencing, quote, a flare of my unrelated autoimmune disorder for which I was not seeking accommodations. A quote, flare is not a medical term, and it is important to note that I did not discuss my autoimmune disorder in any detail in my application, nor was I seeking accommodations based on my autoimmune disorder. These 3 examples illustrate that the unidentified consultants are making determinations about psychiatric disorders and their symptomology, use of psychiatric medications and their impact on associated disorders, and whether a medical disorder, such as an autoimmune disorder, can cause symptoms similar to other psychiatric disorders. To be qualified to make determinations in these areas, the consultants would have to have graduate degrees in psychology, psychiatry, and medical degrees. If and only if these qualifications, if and only if they have these qualifications, should they be allowed to make such assessments. This is especially true given that these assessments are in direct contrast with the 3 PhD qualified professionals who contributed to my application. Because the quote consultants are unidentified and their qualifications are not provided, I cannot determine whether they have the requisite degrees and experience necessary to assess my disabilities and determination of accommodation if necessary. Without transparency as to who these consultants are and what their qualifications are, the accommodations process will continue to lack credibility and integrity, and the merit of each denial of accommodations will reasonably be called into question. Thank you.
Thank you for your comments, Melissa. We do appreciate. I am going to give Alan Shea just a split second to raise his hand if he still wants to speak. I saw his hand go up and then go immediately back down. And not seeing that. Oh, Alan, did you have any comments to make?
Hello, can you hear me?
Alan, yes, we can hear you. Do you have some comments that you would like to make?
Yes, I would. First of all, I'd like to thank the bar for this forum today. I'm a graduate of law school back from 1989, and my journey through this extreme process has been unbelievable. It sounds from a lot of the comments made from the the speakers, and I've been on the phone since 10 o'clock this morning trying to get through, that the process needs to be overhauled and there needs to be some true pathway to create a way for candidates who are disabled to truly reach their goal of being a lawyer without being shut down. And this is primarily for repeat applicants, such as myself. I've taken the bar with special accommodations for a number of decades. I'm not going to even mention how many. And I just learned of my disability being in existence after I had started taking the bar exam. So I didn't even know that I had a disability until I started taking the bar, which growing up, I sensed there was something wrong, but because of my household and the conditions and things, I didn't know. And I was able to get through law school, college, and high school by getting help, by having guidance, by understanding what I'm faced with. However, with the bar, as it relates to special accommodations, there's no assistance after you get your bar results, information back with special accommodation and the issues. And it would be almost impossible for someone to even develop it because they don't know what your specific disability is unless they've been able to evaluate you thoroughly to assist you. So in my comment to you as the bar, my hope would be that there would be a best practice approach for repeat applicants who have an extreme disability condition to get their license issued, because they should not be denied their license because of a disability. If they have gone to law school, gone to college, and they have been a candidate for a numerous times for this examination, there should be a number of times in which they should sit for this exam and be able to be admitted, just like you have when it comes to a qualified license for students who's never even taken the bar. So there should be some method for that so that these individuals are not denied or discriminated because of a disability. These things are crucial, and I'm sure there's tons of candidates like myself who are going through this but are either afraid to speak out or embarrassed to speak out, because it is an embarrassing process that we don't control. I don't control when I go into the bar and take the exam. But what I do know is I've been there numerous of times to where there just is not a way to get past the bar because of my disability. And based on law, that seems to be a barrier that presents a discriminatory approach, that something should happen. I've gone through law school. I've submitted all the documents to become a candidate for this exam. But my disability has conclusively identified that I can't pass this exam because of that. That's not fair. And I've lost many years of my attempt to want to be a lawyer to have my license issued. So to me, it is clear from all of the discussions that have come forth today that the bar exam really needs to take this form very seriously and reformat their process. They need to have a very clear introduction approach for new applicants to get their verification of accommodations for the exams without jumping through all these hoops, because no one knows what their conditions are premised on. 2, there needs to be a true method for those who are repeated applicants to get through this exam. They should not be committed to taking this thing forever and ever, and it just doesn't make sense. They've gone to school. They've gone through the form. They've gone through the fundamentals of what law school, the practice, the awareness, the research, all the things are. This is just a test. And every attorney that I've ever spoken with has indicated to me that once they have taken that exam, it has no bearings essentially on their true practice of law or how successful or unsuccessful they are. Every attorney I've asked, they've all said the same. It's just a test, a standardized test. But we don't all go through the top 10% law schools. We don't. We're not all the top 10% test taker, whether we go to a top school or not. We're different. We're society. And just as being a part of society, we should be able to be admitted to practice law with a license, even if we're not the greatest test takers through this process. It needs to change. And I'm hoping through this forum, you'll create that in those that are listening to all of the speakers today, and especially my comment, let's make some changes. Because I presented this to the bar in 2020. Same argument I'm making now. I presented it to them because it had come to their attention that they need to bring their standards up to meet each individual's specific disability condition. And that hasn't happened. You still have the same standardized process, same standardized test, and it's not based on each individual's specific disability condition. And in order to overhaul this, you're going to have to overhaul a lot, or just set up a practice in which its best practices to achieve the end result. And the end result should be to issue a license, and you have safeguards in place to find out how people are doing after the fact. You still have the same thing in place that you have now for attorneys who are not in compliance with the standards of practicing. That'll still be applicable to us. So you have that standard already. So I hope that this conversation raised the awareness that we need to focus in on how to get people into reaching their goals of being getting their accommodations, and certainly for those individuals who have been down this journey many, many times, and they don't have any other recourse but to keep taking it. And it may not ever seem like they will ever get their license. And that's not why we've paid all this money and it's taken this journey. And just to let those listeners who are listening, I've probably paid close to $100,000 during my journey for this, because that's how passionate I've been to be a lawyer since the age of 6. And yet it hasn't happened because something I can't control, nor did I know when I was at that age. So please take this into consideration going forward. Thank you.
Thank you, Alan, for your comments. Again, in the interest of giving everyone an opportunity to make first comments, I am going to skip down the list to Claudia. Claudia, would you like to make your initial comment?
Sure. Thank you for including me. This is Claudia Center. I am the legal director of Disability Rights Education and Defense Fund. and I've been working, like many others in the disability community, on disability access to the profession for more than 20 years. I often work with my colleague, Ginny Kim, who works at Legal Aid at Work, and we work together in coalition on these issues. And what I'd like to focus on today, I really appreciated the commenter who came right before me, that this is a long-standing problem. And those of us in the disability community and the disability advocacy community, we've been telling you over and over again how we think the accommodations on the bar exam should be managed, assuming that we retain the bar exam. And I would just like to emphasize that this has been a long time. The ADA was enacted in 1990, and since then we have been endeavoring to apply the ADA to the legal profession. And this includes our work getting the American Bar Association to understand disability rights and to implement disability rights in its programs. It's about the Subcommittee on Access for People with Disabilities that is part of the Access and Fairness Advisory Committee of the California Judicial Council. That started in 1994. Disability was added to the diversity goals by the American Bar Association in 1999. So this, you all are late. You all are really, really, really behind how the bar exam accommodations process should work, depending on whether we retain the bar exam. I really think you don't need to reinvent the wheel. We know how accommodations should work in high stakes testing. We know this because the California Department of Fair Employment and Housing brought litigation in 2012, 10 years ago, against the Law School Admission Council regarding its accommodations process, which was screening people out from the LSAT, screening people with disabilities out from the LSAT. You can look at the consent decree from May 29th, 2014, which is housed on the dfeh.ca.gov website. You can look at the best practices report from the expert panel, also on the DFEH website, January 26, 2015. You can also look at the US Department of Justice Disability Rights Section guidance document on testing accommodations. I will review very quickly some of the high-level principles that these documents and that this approach includes. First, the State Bar should presume that any individual who's previously been granted disability accommodations on law school exams or on standardized tests for post-secondary admission like the SAT or the GRE should presume that that individual has a covered disability for purposes of accommodations on the bar exam. Just cross that off the list, presume it. Second, all disability accommodations previously granted on standardized tests related to post-secondary admission, like the LSAT or the GRE or the SAT, or on law school exams, timed law school exams, should be automatically granted on the bar exam. 3, the State Bar should defer to qualified professionals who provide documentation based on careful consideration of the applicant. Defer to those professionals over the consultants that we've all struggled with on our side of the table. The State Bar should streamline the accommodations process and limit their documentation requirements to those that are reasonable, limited, and narrowly tailored. And the State Bar should not consider academic success as any reason to deny testing accommodations. In large part because of the work of the disability community and disability advocates in implementing the ADA into undergraduate and into the LSAT process, we now have a pipeline of disabled individuals who are taking the bar exam. And so we've We've removed barriers to get people into college, to get people into law school, to get people, to allow people to take the LSAT. And so now people are going through this whole process and are getting to the bar exam and can't get through. So you need to apply the same principles everybody else is doing in college, in law school, and apply those to the bar exam. Thank you.
Thank you very much for your comments. Again, I'm going to skip down the line to, I believe, someone that has not had the opportunity for first comments. That's Ikram. Ikram, do you have a comment for the group?
No, I'm sorry. I just raised hand because I did not know how to make a comment. Or, I didn't think you could hear me. I was just trying to write down. So that's yeah. I just want to hear out what's going on, and I will make a comment down the road. Raise my hand, but I just wanted to find out if I can actually make a comment. So I thought somebody would give me an icon where I could write down that I'm ready to talk. So I'm sorry. Yes, I will make a comment down the road. Yes.
Okay, nothing to apologize for. If you lower your hand when you are ready to make your comment, you always can raise your hand at that point, in which case I will go down the line and call on you just as I just did. I do not see any first-time commenters, so I am going to go back to the list for second-time commenters. And I am first going to check in with the Los Angeles and San Francisco office before I go back to Zoom.
LA here, no new members of the public are in the conference room.
Thank you.
San Francisco either.
Thank you very much. I am going to go over to Kissy. Kissy, would you like to make your second comment? You have 5 minutes. Kissy, are you able to unmute yourself? Kissy, I do not hear you. I do not see you coming off of mute, even as I try to unmute you. So I'm going to move down to the list and Kissy, are you there? I see you just went off of mute and then back on. Okay, I'm going to move down the list. Benjamin Cohen, would you go ahead and like to make some comments?
Yes, I'm making a second comment to follow up on some of the descriptions about the consultants who are being relied on to override treating experts and healthcare professionals. Before I talked about the procedures, but substantively in the decisions, it appears as though the State Bar has a couple unnamed consultants on the budget for psychiatry, psychology, and visual disabilities. I'm not sure if that's an optometrist or ophthalmologist. I know that most of the rejections that I experienced were made by a psychologist. This psychologist was able to recommend denial that was adopted without scrutiny over 8 experts across multiple specialized physicians for physical disabilities, including being immunocompromised, digestive disabilities, myofascial pain and related disabilities, and the like, who were never inputted by a physician that was disclosed to me. But the psychologist also, of course, was able to review the pure psychology, neuropsychological evaluation reports, and recommended denials of what treating PhDs wanted there too. Usually when that psychologist who reviewed mine made denials, they explained in their reasoning contradictions of clearly established legal standards, like substituting what best ensures a level playing field to what has been proven medically necessary in the absolute sense, with no other factors being able to surmount handicaps remaining from denials. They have claimed experts that had previously written into my testing accommodations were new experts when they had been written in before, and ignored what was said in previous documentation, or maybe not read them or whatever. They did not recognize that a lot of the information that they cited to be omitted as reasons for denials had been provided in the file previously, while saying that only newly provided evidence could be considered as a matter of admissibility. I don't know where they got that from. If that's a state bar policy, it should be removed. Then they also do not defer to assessments by qualified experts, but they don't explain to the experts for purposes of appeal why they disagree. They find things that they perceive or allege to perceive to be omitted, and even a single thing that they would have liked to consider that may or may not even be relevant, that they don't feel is clearly explained, is a reason that they can recommend denial without explaining why the weight of the evidence is still in favor or not of that outcome, even without knowing that piece of information. And then they come up with new reasons when the experts provide the information they sought. But since the process takes so long and you only get so many iterations per exam cycle, this of course means that these moving goalposts mean not equal opportunity to get a decision based on the full analysis of the material information in the same exam cycle, and instead creates having to wait years through multiple attempts at the applicant's expense at the bar exam. This psychologist seems to be the most blatant, but in general, I have not seen most of the expert consultants constrain themselves in clarifying that their recommendations are only based on their specialty. If they recommend denial based on of requests outside their specialty, it's summarily accepted by the bar, even if they haven't restrained themselves to what they have qualifications for. And as earlier commenters have said, their qualifications aren't even really disclosed, because you have to look up from the budgets who the state bar is contracting with and getting contracts for, to know who these people are, and piece it together based on what they address. Then, secondly, when there is new information requested, that is being cited by the state bar when provided as a reason to delay. I know that in the pandemic for October 2020, I was going on the reasons the state bar provided for the first time on appeal for February 2020 as to why it denied many requests I've been making since for July 2018. And I responded to those initially in March with mostly legal analysis about the reasons given, but the state bar had disclosed to me that they were not considering my physician's recommendations based on a report by a deceased psychologist, because he had not personally redone the testing. That wasn't supposed to be required, but I did it at thousands of dollars and 20 hours during the pandemic personal expense as soon as the shelter in place lifted. But the state bar said that I should have done it sooner, even expediting it to as soon as the shelter in place lifted, and as a result took over 5 months to process my petition, and then ensured that the first meeting it would be considered at was the same day as the deadline to appeal denials of testing accommodation results. Even after the exam had been postponed, the deadline was not proportionately extended for either that to allow for decisions after that meeting to be appealed, or to have new accommodations made based on the changing standard conditions of the exam with the dual remote and forced in-person formats until 4 days after standard test conditions were disclosed was the final extended, disproportionately short extension to how the exam was postponed to deadline for that with most other incarnations of the deadlines coming before standard conditions were even disclosed for that exam, whether it would be remote or not, whether for some people or all people, what the rules were going to be that might interact with disabilities in each case for exam security, whether it would include the MBE or not, all of those things. So I want to emphasize that procedurally, the purpose here is to get a clear guidance on what information the State Bar needs to consider, not consider omissions beyond what was not requested as reasons for denial, and to make it adequately responsive so that if in collaborative, so that the concerns can be addressed in time to have all the information considered and still receive a decision in time to equally have opportunity to prepare for the exam. Applicants with disabilities should not have to commit third-party exam prep expenses and full-time study at risk in order to, on speculation about whether they'll have an opportunity to take the exam with equal opportunity. That's not equal opportunity, nor does having the procedures chill their ability to apply for testing accommodations because it's so burdensome. That doesn't provide equal opportunity too. The substantive result is to best ensure a level playing field, and the procedures need to provide equal opportunity and in time to provide equal opportunity, not just to take the bar exam, but to take the same exam cycle that other people without the disabilities would have been able to take it. So I know the DOJ also has given those guidance documents that Claudia mentioned. I know they're investigating whether the State Bar is in breach of those things and awaiting applicants to share their experiences through the OCR portal as well in order to carry out that investigation. And I urge you to follow the DOJ's guidance. I'm sure if they would take your input as part of the investigation. They so feel like it's not being cooperated with, but they would, and maybe help with this guidance you want on how you should change things to make this process meet the letter and spirit of the disability non-discrimination practices. And you should assume that the UNRU Act standards also apply as we await the California Supreme Court decision in Brennan B that is imminent. Thank you.
Thank you, Benjamin. It looks like we are still on our list for people that would like to make comments a second time. So I am going to go to Shirley next.
Hi, thank you. So some issues came up. I didn't request to have a staff member transfer my multiple choice questions to a Scantron for the February exam, but it was on my notice and I did not notice it until the day of the exam. They were going to force me to do it anyways, but I told the proctor that I wasn't comfortable with that. The proctor had to go downstairs to get the bar admission staff. They hastily typed up a waiver stating that I refused the accommodation. That is an example of the attitude about accommodations. Accommodations are not required. They are an option for the test taker once they've been approved. So I really recommend that staff get trained on that. The bar exam portal does not allow you to submit testing accommodations early if you're requesting the same testing accommodations as previously granted, because I did try last August of 2021. I never got a response on that. I recommend the bar establish a disability committee comprised of professionals trained in learning disabilities and physical disabilities. I also think there should be an exam applicant advocate that can assist applicants through the process. I don't know how that would work, but it's really important. I recommend hiring more staff and have them properly trained. The ratio should be no more than 20 exam applicants per staff member who are requesting accommodations. I recommend all bar testing admission staff and decision makers attempt to submit an actual application or a request for accommodation as a new applicant petition and as a repeat taker, so you can understand the process that we go through, and you're going to see the glitches. I recommend a separate web page be created for those requesting testing accommodations on the website because the website is impossible to navigate and it's not designed for people who are requesting the same accommodations as previously granted. Before launching a new web page, please have it tested by exam applicants. The timing of this forum is telling. Yesterday was the baby bar exam. For those people with accommodations, it's also today. They weren't able to participate in this forum because they were studying for the baby bar. So the decision makers need to have a little bit more sensitivity as to the timing of when they request information from exam applicants who've requested testing accommodations. Also, the deadline for modifying or appealing is July 1st. The timing of this couldn't be the worst time of the entire year. And then we have 3 weeks before the bar exam coming. So again, please be mindful of those things and take into consideration the needs of the stakeholders. Please instruct the proctors to be quiet during the exam to avoid unnecessary movement and not talk while they are in the testing room. My proctor got up and down 40 times on day 1. She would stand literally next to me, right next to me, and work on paperwork in order to stay awake. She was basically doodling right next to me. I finally had to ask her and tell her that it's really distracting for me and it's counterintuitive to the accommodations I was granted. And she was a little annoyed with me that I had to ask her that, but I had to, but I lost my first day. My first day was ruined. Even though I had a private room due to distractions because of severe ADHD. I also suspect that she was trying to stay awake. She coughed and cleared her throat the entire day, every single day of my accommodations. I was not told what the process would be or made aware of any process to ask for a new proctor. If they're going to show up, they need to be able to understand the basic concepts of the accommodation so we can have the spirit of what we got granted and spent tens of thousands of dollars to get. It was just ridiculous. I didn't say anything because I was scared I was going to get a Chapter 6 notice. And I do know somebody, when they raised their question, they got a Chapter 6 notice because the proctor accused them of hitting their arm. So it's very intimidating, and even me, it's intimidating for me. For exam takers who have additional time, please never require them to take an exam longer than they require the traditional test takers. That is a punishment. If somebody is getting an accommodation for fatigue or anything related to that, including ADHD, they should never be required to take the test for nearly 11 hours, of which they tried to do for me. And I've heard many other people say the same thing. I'm almost done. There needs to be more staff with proper and regular training. And so everybody knows, testing accommodations do not expire. They don't expire once you've been granted by the California Bar Admissions, unless you've not taken the test within the last 3 years. Finally, I want to help anybody navigate this process for free. Feel free to call me. My number is 707-349-3486. Lastly, I offered to donate 100 hours of time last year to interview applicants. I work as a private investigator. I get paid very well per hour for the work that I do. And my offer of 100 donated hours fell on deaf ears. There was no response. There was no feedback, no communication. I'm a very good private investigator. I'm very good at getting witness statements. I interviewed over 4,000 people affected by the Camp Fire. I know how to do this. I could easily put all of that information in a collaborative process amongst all the stakeholders and even the staff. I'm sure your own staff members are scared to say something because the person that has been running this department for the last 3 years has kept it that way. And interesting enough, she has not made any comments today or participating that I'm aware of. So I'm done. I really encourage everybody to have their voice heard, to submit your comments in writing, and to get anyone else you know that has physical or learning disabilities to submit their comments. Thank you.
Thank you very much. I am going to move down the list to Mark. Mark, would you like to make some second comments?
Yeah, can you guys hear me?
Yes, we can. Thank you, Mark. You have 5 minutes.
Yes, I just want to reiterate, I just want to touch on some of the things that other people have mentioned before with respect to proctors being you know, speaking outside of the room where individuals are testing in. I personally have lost time in the past on a couple of essays. I mean, I'm sorry, not lost time, but actually lost time focusing, you know, with respect to, you know, the information that was on the essays due to the fact that, you know, some proctors were speaking outside, laughing and joking, having a conversation. So I think after this meeting is over with, I think that is something that you guys should definitely work on in terms of you know, improving the testing conditions. And the second thing I'm gonna go ahead and mention for today is that you know the whole thing does need to be looked at, just like some other commenters have stated in this group, that, you know, our accommodations definitely need to be looked at in terms of, you know, whether or not if a candidate uh, should be given accommodations, because some individuals have been denied, you know, in the past, and you know, the doctor definitely have told these individuals that they do have a disability, but yet they have been denied by the state bar. So that's something that should definitely be taken into consideration after this meeting is over, whether or not if these applicants do deserve accommodations. Thanks for your help.
Thank you, Mark. I do want to go to Nancy next.
Hi, thank you again for having this conference and for granting me another opportunity. I've been listening to everybody speak, and everybody that has spoken has valid points. But I want to play devil's advocate here and bring something to bear. And everybody's probably like, oh God, shut up. Maybe, I don't know. But it would take to in their profession.
Okay, I'm sorry, Nancy, to interrupt. We are unclear on what you're saying. Would you mind starting all over again? Nancy, if you're still there, we would love to hear your comments. Or if you need to call back in, that would be fine as well.
Can you hear me?
We can hear you again, Nancy. Would you mind starting over from the beginning?
Not at all. So I'm going to play the devil's advocate. I've heard many complaints and I've had them myself in the room. I've had to literally yell at the proctor, and I didn't care about Article 6 at that point. I had lost so much time that if I'm going to fail the bar, let it be because of me and not because of some proctor who doesn't understand that I'm in this room because I need the quietness and not the talking and chattering and yeah. But the point I want to make is we're taking this test so that we can be admitted to a profession that requires the utmost integrity, utmost honesty, transparency. And there's a lot of people in the world who could care less about that. So they will try to use and abuse. So on behalf of the bar, I understand if they make the process easy, but at the same time, the people who are trying to become an attorney, this has been a 20-year journey for me, but because I've had major back operations in between. I've had deaths in the family in between. My son was also murdered 3 years ago. And so basically, it's really a hard place to be. It's a fine line that we have to walk and a fine line that you guys have to walk. And I think that we really need to work on it together. And I'm saying all this to say that going through the entire process that I went through, I used to begin to doubt myself, like, are you mentally able to do this? Because part of the moral character determination application asks you, are you mentally able to do this? Are there issues with your mind that would prevent you from being able to carry out the duties of an attorney? And so when you're going through all of this, you begin to actually doubt and question yourself. I have ADHD. Okay, my mind runs 1,000 miles a minute. Doesn't mean that I am defective. It just means that my mind operates differently. So I can't fit into the mold. But by the same token, you guys are trying to make sure that the people that get in are actually worthy of getting in. And I'm not saying anybody on this forum or anywhere else is not worthy. I'm just saying that it's really difficult to do what you guys have to do. And it's difficult for us as well. And I'm open to working with you guys. I went through it 3 times. And I don't know how I can help, but I am offering to be of service because I do understand both sides. And I'm sure everybody else does too. But because I passed, I can kind of let go some of that anger or frustration or demoralization or anything else that I may have felt before I passed, because I felt the same way many of these speakers are speaking. Like I'm already at odds and I just feel like I'm being beaten down by the system, but I'm gonna keep moving. So that's all I wanted to share, that I understand you guys, meaning it's not us and them, but the state bar has to ensure that the people that they're allowing to enter are of the people that can be trusted with other people's lives and other people's well-beings and their finances and their, just law, whether it's criminal, financial, family, doesn't matter. You're entrusted with other people's lives. And an attorney who's not ethical or who's not actually equipped, who doesn't have who passed the bar, but I don't know how, they can ruin a person's life. And I'm one of those persons whose lives was ruined. And I can go into a whole subject, but time does not permit regarding that, which is what made me become an attorney at 58 years of age. That's all. Thank you very much for the time.
Thank you for your feedback and comments. And we are going to move on to Jay.
Hello, can you hear me?
Yes, we can. Thank you, Jay. You have 5 minutes.
Okay, thank you. The last caller made little to no sense. I'm sorry. The whole thing that we opened up about was testing accommodations with people with disabilities. That has nothing to do with utmost integrity, honesty, or for you guys to ensure that we're honest and to the utmost as far as attorneys. Nothing at all. In fact, she needs to talk to her Supreme Court justices if she feels that much. This has nothing to do with, our honesty and our integrity in taking this darn exam. Most of us, as you heard today, had a real big problem with other people overriding medical decisions and we not knowing exactly who these physicians or nurse practitioners or LPNs even, I don't know who are making these decisions. They're basically, like someone said, phantoms regarding their credentials. Most of us want some transparency. That's number one. That's all I really ask for is, okay, if you're overriding my doctor's position about me being blind and seeing nothing but blurs, please tell me why that's not valid. And we're not getting that timely. And when we do get something, it's not enough time to address an appeal or anything. That's what we're dealing with. I'm sorry if you guys are understaffed or you don't have, or you're not farming out to, credentialed physicians to make medical decisions or whatever. But like most of us, we paid hundreds of thousands of dollars to get to this point. We fight to get into law school. We fight in law school. We fight to get out. And now we're fighting to have accommodations that at least will help us gain a bar card. Once we even pass, this has nothing to do with our integrity, honesty, or anything of that nature. I'm not attacking the committee of bar examiners, but you've heard from too many people. It's a joke at best. This website, whoever nephew put this together, it's almost as good as the one in DMV. It is not great to navigate. It's very difficult. People have said it. And then when you finally get response, you got to navigate again and waste more man hours calling people downtown to say, hey, what do I need to do? I've called several times, and luckily people had to walk me through it because it is not easy to navigate. And like I said, I don't know why it has to take so long for answers. But once you get an answer, you want to know honestly, why am I denied and who denied us? And, let my doctor then see what this doctor said. That's all any of us have ever said. And that's why a lot of us think there's a big bias against ADA applicants and against, like I said, the non-traditional law student. This is not a new, dog and pony show here. It's unfortunate. Oh, and further, someone wants to bring up, other states, have similar. No, they really don't. They really don't. This is unnecessarily difficult. And it's like your job is like I said, a bad insurance adjuster. We pay the bill for coverage, but you're collecting information to get as much as possible to deny us. That's what it feels like. Not necessarily getting information to make sure all our boxes are checked, but getting information to, okay, well, let's Google this to see if we can find something, against it or something. It's really, it's horrible. It's absolutely horrible. I don't think we, are paying a bill to put you guys there to look for reasons to deny. If we meet the qualifications, let us do what we came to do. If we don't, tell us what's missing in a timely manner so we can get it. And if we don't have it, we understand it was our burden and we failed. We don't need to be going against the Committee of Bar Examiners 2 as another adversary to get out of this situation. That has nothing to do with someone's integrity. That's a joke. You got more people that have passed the bar that talk to your congressperson, see how honest they are. I don't need to hear that. I just need to know who's making decisions and what will it take to get timely decisions pushed through. I thank you very much. Yield my time.
Thank you. And I would like to once more thank everyone for their comments today. I do appreciate it. The State Bar appreciates it. Let's see, it looks like we do have a new comment. I am going to ask that Isaiah is promoted and is able to
Yes.
make comments.
Yes, thank you very much. Can you hear me, Christina?
Yes, we can, and you have 5 minutes. Thank you very much.
Thank you very much. It's very brief. So my comment is regarding the testing accommodation, the information provided during the testing accommodation sometimes is used or misused for other purposes. For example, I can't talk to details, but at some points I was at the State Bar for some character and fitness kind of informal hearing. So during the hearing, this informal hearing, I was being basically grilled, asked about my medical condition, which has nothing to do with the hearing. And when I provided my medical information, and in the process of the testing accommodation, everything was available to the State Bar. There's nothing I was held, no information. I didn't hide anything. Everything was just in their position. So, however, during this hearing, I was being asked multiple questions about my medical condition, regardless of whether I could be triggered, because some of the things I was being asked was, it triggered some trauma, past injury and psychological, some other issues. So my concern is that, when you provide information for testing accommodation, it should not be misused, or, the State Bar should not take advantage of that and try to use it for other purpose, unrelated. And when I was asked about that questions, details of my medical conditions, I was not even prepared to answer that, because the hearing was not about medical issue or testing accommodation. It was completely different matter, subject. So just want to address this issue. Thank you.
Thank you very much for your comment. Why don't we go back to San Francisco and LA just to make sure that anyone that showed up in person has opportunity to make comments.
LA here, no new members of the public currently.
Thank you, LA and San
These are
Francisco.
the San Francisco.
Thank you. At this time, I also see no other people looking to make comments in our attendees pool. However, this meeting is scheduled to go until 4 o'clock. So I do want to keep this Zoom link open for anyone else that might want to attend. But having said all that, I think in the meantime, if we could just take a 10-minute break for everyone. That's a 10-minute break. That's at 3:05. If everyone would like to come back. And if there's anyone that wants to make comments, they are more than welcome to. Again, at 3:05, we will go on a 10-minute break. And thank you all very much. Okay, thank you, and welcome back to the group. I am going to move right back into our line. Marvetta, would you like to make public comments for 5 minutes? Marvetta, are you able to unmute yourself? Marvetta, are you able to hear us? And can you unmute yourself? Oh, Marvetta, are you there? I just saw you go off mute.
Hello, Christina?
Yes, Marvetta, we can
Oh,
hear
I'm
you.
so
Thank you.
sorry. I was trying to figure it out. Hi, my name is Marvetta Evans, and I'm here because I finally got my testing accommodations through the state bar, but this is not my first time. Initially, I was denied, and I had to go back and get a report done and all that. Had to go to a series of doctors, but the entire process was just a little bit too much to bear. And it still is. And I didn't get everything I asked for, um, but I should have. So I'm kind of concerned about, pondering, should I go back and appeal the decision for which I was denied for, or just accept that, okay, you got some accommodations and be grateful.
Sorry, Marvetta, I'm not sure if that was a question. I'm not taking questions on this forum. Did you have additional comments that you would like to make?
In regards to the State Bar Testing Accommodations Department, in a positive light or negative light?
We always like to hear positive, but of course, positive and negative feedback is welcomed.
No, Christine, what I'm saying is I finally got the accommodations that I want, but I didn't get everything in its entirety. So, and I'm kind of wondering why.
Unfortunately, I'm not taking questions on this forum. I don't have your file in front of me, and I wouldn't even be able to tell you exactly why you weren't given accommodations. However, you do have a few minutes left if you would like to talk about the process, what has worked, what hasn't worked, any comments that you would like to make for this group.
Well, number one, what has worked, Christina, is that you got to be diligent. You can't give up. Even if you're being denied, go back and appeal that decision. The process was really too long because I think someone should have told me from the state bar that it was going to be more or less a lengthy process and what to expect. But I was lucky enough to get a wonderful employee with the State Bar of California, and her name is Maria. And I tell you, if it had not been for Maria, I don't think, number one, that I would have endured the process. I would just like, forget it. It's just too much. But she kind of helped and assist with the process.
Thank you very much, Marvetta. Is there any other comments that you would like to make?
No, not at this time.
Thank you. Appreciate you being here for this meeting. I am going to move down to Alan. Alan, would you like to make your comments?
Can you hear me?
Yes, we can. Thank you, Alan.
Well, first of all, I just want to thank you again for hosting this event, because I think it gives the applicants again a chance to hear multiple perspectives of this journey. Is there going to be a final determination made on the information that's being provided to you? That's what I'm hoping to get an answer on. And two, I'm hoping that out of this, we will create a method so that it's not so much stress in the process of being approved or getting our bar license. So I'm hoping that those things will come to a head with this forum. Otherwise, I think if we don't get some kind of resolutions, it can have an adverse effect on us because it's going to show that the bar really doesn't care. And these things are just being put out here just for PR, I guess, because we really need to do something and to overhaul this process. Thank you.
Thank you, Alan. Appreciate those comments. Deb, would you like to make another round of comments as well?
Sure, but only in the interest of, keeping the meeting going for other people to join. If, I wanted to elaborate on the, my idea for changing the testing and what problems it solves. But again, if there's somebody else who has something more important right now, I mean, I can yield. I don't want to take anybody else's time up. Is that okay?
That is fine right now, Deb. I do not see anybody else that has their hand raised. So your choice if you would like to proceed.
Oh, great. I would just love to enter the more expansive idea into the record because I'm really a big fan of changing this format again after I pass it. But okay, so the first problem I saw is that you're receiving increased requests and even lawsuits to allow online testing by those who have immune compromised problems. And they will continue to be at risk even after we stop worrying about COVID. So these people shouldn't be left behind when the public emergency is permanently ended and we stop worrying about it. On the other hand, some of those accommodations that may be necessary for the immune compromised, such as masks or vaccinations, would be disabling for others who are not able to comply with that demand. So those are two equally important but diametrically opposed needs. And then we're battling with, diminishing resources and availability at the moment, including fuel and materials and, whatever the fault for that situation. This isn't going to get better anytime soon. Courts are moving, I've noticed, to internet-based hearings, and I believe that people are even searching and using technology during these meetings. So if so, then it might not be necessary in the near future to prove that a lawyer can immediately recall certain facts or information in order for them to function adequately in court. And I'm not sure if that's one of the rationalizations for the memory heavy focus of the tests, but it's a potentially salient point if that's the case. For you're being sued over ADA accommodations, many of which require really non-standard setups to truly meet a person's needs. I'm not suing you, but I'm actually one of those people who has an odd need. I have cluster headaches. So, I mean, there's all sorts of problems that I'm not going to bore the audience with. It's not salient to the point. 5, test takers need cost reductions due to economic circumstances that are beyond our control at the moment. I'm highly dubious of an economic recovery in the near future. I bet a lot of people are. And you as an organization also need ways to reduce costs right now. So the reasonable solution to the problems would be to change the testing format in response to changing environment. An open book performance test would keep the standard for the bar in line with changing needs of the general public and serve the public good by allowing you to select members that can demonstrate real world skills that lawyers use today. And it will serve the legal profession by providing more competent members who can actually use a computer and research in the new formats. Of course, you have to accommodate people that can't use computers as well. But this is a general skill that's going to be required for most lawyers to be competent in the future.
And we have to consider the general public good and allow future lawyers to demonstrate competency and skill sets that meet changing public needs. It's a much more valuable skill set than memorizing a bunch of trick multiple choice questions that will likely never apply to real world skills. I passed the multiple choice questions. They don't demonstrate actual competency, although I am competent. They're a trick of memorization. I don't agree that performance tests should be untimed. My testing accommodation requires time and a half, and I still don't agree with that. The ability to perform a test in a reasonable amount of time demonstrates the ability to generate work for multiple clients. And that school must be shown with reasonable accommodation. So my suggestion is an open book, internet-based test that allows any notes that the test taker should need in a Word document format that can be seen on a screen recorder. If the test allows internet searches, and I recommend it should, since it's a real world skill that we should be able to demonstrate, then the screen recorder can ensure that there are actual internet searches and not, God forbid, a copy of the actual test answers, although I just don't know how anybody would obtain those. But you should also probably scan the room for reasons of fairness, although just most people that are taking the bar are far too mature to cheat. But just for fairness, to ensure that nobody else is in the room, there's no copies of it. And you can record audio in the room as well. There's no reason that you can't perform these tests, a test like this online. And that format would solve the travel problem, solve the immunocompromised problem. It would solve, the screen recorders would ensure that people with visual disabilities could use larger screens. This would solve those problems. It would accommodate those with memory-based recall. It would dramatically cut costs for administrating the bar. It would adapt the test to testing format to show newer skills, and it would allow flexibility and adaptation for those with unusual needs. So when they're coming to you with an unusual accommodation need, they're not getting a rubber stamped rejection, because I'm hearing this too. And the truth is, the first time I applied, I also got a rubber stamped rejection. And I don't know who did it. I had, doctors and well-trained people submitting the same information that was approved by my law school. And it wasn't even a very complicated request. So I think this is a perfect solution. And I'm hoping that I know it's just a seemingly insane idea for the bar to change this much, but this is not the 1980s. This isn't the 1960s. This is 2020. And our lives, whether we like it or not, are moving into a virtual environment. And we need to demonstrate an ability to adapt to this and to adapt the changing standards so that we can ensure that the skills that the Guild is approving for new members are actual skills that are demonstrated and applicable to the real world environment. And okay, that's it. So hopefully somebody else has another comment now.
Excuse me. Thank you very much. And we will move on to Taylor. Taylor, would you like to make a comment?
I would, and it's not necessarily a comment, but I know y'all aren't answering questions, but some information that Deb might find useful is there is an ongoing Blue Ribbon Commission within the California Bar to discuss the future of the bar exam and how the test might be changing in the future. The NCBE is going to be changing their exam in 2026, resulting in necessitated changes to the California exam because the MBE will no longer exist come 2026. So if you are interested in concepts around the future of the bar and how it might change and what it is looking like in the future, I would recommend looking back at what has happened in those meetings thus far. And if you're not taking the July exam, maybe watching as a public member for the next July meeting, which I believe is the 19th, or if you are taking the July exam, hold off and attend the meeting in August. But I just wanted to throw that out there because I think that might be helpful. And I know that the Cal Bar isn't speaking on this. They're not answering questions because that's not the point of the forum today, but I did know that detail and maybe thought I could be a little helpful. And that's the professor in me. Keep trying to help.
Thank you, Taylor, for that. Let's see, let's go over back to Deb. Deb, would you like to make a comment?
No, just a question to my fellow attendee. Do you have information on how to attend that? Thank you very much.
All information regarding the Blue Ribbon Commission is posted on the State Bar websites. State Bar website under the About Us forum, there is a Blue Ribbon Commission link with the agendas posted 10 days in advance and upcoming meetings.
Thank you.
And I am being told that the next BRC, the Blue Ribbon Commission meeting, is on July 19th. And Deb, I still see your hand up. Did you want to make a comment?
Oh, no, sorry.
No problem. And if there are no new questions here, I am going to turn it back over to Benjamin. Benjamin, would you like to make comments?
Yes, please. I wanted to speak about the policy against answering questions. I wanted to note that I don't know how many people were attending start to finish, either among State Bar staff or among attendees, but there was a time where a staff member presiding had asked follow-up questions of the speaker and allowed them to ask questions in turn that was answered. And that wasn't at the beginning, and it wasn't for the last couple hours, but there was a time where that was going on. And I wanted, in the interest of fairness, to remark that speakers who were commenting at different times who had questions, I wish that they could be given some of the same opportunities, either to have answer questions of staff about their comments, or to at least try to get some questions. Maybe the State Bar can't answer everything, but if there wasn't a categorical policy being consistently enforced, that there at least be some discretion being given to make it consistent and fair. I know I would be happy to answer some questions about my two comments before this, but aside from that, I just wanted to point that out.
Thank you, Benjamin. I don't see any hands raised at this time. I don't see any comments coming through.
We have no attendees in LA at this time.
Thank you. Okay, I do have one person that has raised their hand. Ikram, would you like to make a comment? And Ikram, are you able to take yourself off of mute?
Okay, can you hear me now?
Yes, we can hear you. Thank you.
Okay.
You have 5 minutes.
No, I was thinking, like, I don't know, this may not work, but when you are diabetic, which is what I am, and I'm very brittle. I have no idea. There are times when my blood sugar crashes down when I'm not expecting it, and that's what brittle really means. So it takes a while to stabilize the sugar, and it takes time. So for those kind of things, do you guys have anything on the agenda? Like you may give me extra time at the end of the test to finish up my test because I took this much time to be able to stabilize my sugar. And then also there was the lady who said she was a private investigator and she wanted to discuss things, she was offering her phone number. I didn't get her phone number in the transcript. Could I get that?
Ikram, I believe you asked specifically about your individual testing accommodation file, which I'm not able to answer on this forum.
No. I wasn't necessarily asking individually. I'm just asking about in there any situation where somebody who's handicapped and they have to spend some time doing something that distracts them from the exam, and that much time, could they get that back at the end? I know if you are going to do it, it costs you a lot of money. For the what you call it, the people monitors to time, how long it took you, and then to give you that time back and say, okay, you can finish it. You got this many extra minutes to get that's how long it took to recover from what you were doing, to what your disability cost you.
Well, I can't necessarily speak on the policy. Each individual case is different. If something happened to you where you lost time, I would encourage you to write in on what happened. I'm not able to address anything right now, unfortunately. Do you have additional comments that you would like to make?
I just wanted that young lady gave out her number. I don't see it in the transcript. Is there any way I can get that number?
If she is still on the phone, we can request that she raises her hand and we can call on her again, or that there will be a transcript of this meeting that will be posted on the State Bar website at a future time, in which case the transcript will most likely have her phone number, as long as they were able to capture it.
I did not see it. I've been watching the transcript as we go along, but I did not see it in the transcript.
Okay.
And that's all for me. Thank you.
Thank you. And we will go ahead and move to Alex next. Alex?
Hello, good afternoon. How are you? So I would like to just bring up two issues. And the first is on behalf of everyone that has ADHD. And next, I will talk about my personal situation and how it's been affected and my course of action from here. So first, to start with the individuals with ADHD, it's an extreme miscarriage of justice, and it's a violation of ADA standards. The manner that the State Bar has addressed individuals that I am aware of, including myself. They have provided false and inaccurate justifications for their denial. Obviously, these will be highlighted in an appeal which you will receive by the 1st. But separately, the motive of this course of action and this pattern of action must be looked at. And there must be a reason for this. And I believe that this is a financial motive by this California State Bar, because each individual that will be forced to fail this exam will then possibly and likely have to take the exam over and over and over again with the accommodations deprived. And these individuals are a big pay ticket for the ABA. I'm sorry, and for the State Bar. And this is not what the ADA was established for. It was not established to deny people their rightful accommodations, to cause them to fail exams so that the State Bar can profit off of it. That's not what the ADA is for. The ADA was to protect those individuals with disabilities and to provide them access to the exam. For individuals with ADHD, the only way they can have access to the exam is to have additional time to take the exam. This is a certainty, and this is a fact that is undeniable and it's unequivocal. And I hope that the State Bar can look at this issue and consider the ramifications of potential punitive damages that could be awarded for this type of motive in bad faith, because individuals with ADHD to be denied and deprived their accommodations is a violation of federal law, and it will not be tolerated by the students. And if it is shown that this is a pattern, and that if this has ulterior motives, then indeed punitive damages are warranted, because there should be no reason why individuals that are providing legitimate proof of their disability, and other institutions like the LSAC and law schools that are providing and agreeing and adhering to the AD and to the ADA, and they're providing these students with their accommodations, and then the State Bar all of a sudden says no. In other words, you can spend all this money on law school, but guess what? You'll never get granted the accommodations because we want to keep you in this system, so you keep failing the exam, and we keep getting paid over and over and over again for each of those failures. And this is unacceptable. This will not be tolerated. And a legitimate disability and any type of denial of accommodations of a disability will by no means be tolerated. I have personally sued the LSAC. I have made a difference with regards to policies. If my appeal is for any reason not granted, I will certainly file a lawsuit, because nobody is without rights. California State Bar. I think if anybody should know that, it's the California State Bar. Everyone has rights, particularly the ADA provides us with protection, and we have every right to file a lawsuit in regards to any denial that is done without justification. So I ask of the State Bar to look at each situation carefully and to make sure that there is no pattern going on here, because the fact is that I saw different responses from other individuals that were denied, and I saw language that was extremely similar, and it was indication of a pattern. And this is indicative of a decision that was made for bad motives that were perhaps financial, but not made for the best interests of the potential applicants, and to perhaps sacrifice all of the money that individuals spend on their legal education, and to deny them the accommodations and to deny them the opportunity to become an attorney is unconscionable, and it does warrant punitive damages if it is to be proven that there is any type of wrongful motive behind this, because this action will definitely be overviewed, and there will be policies of the ADA that will be holding the hand of these individuals that were denied, because the ADA is a resource for anyone that has been denied wrongfully. The ADA will assist them to take legal action, and nobody is helpless. I just want everybody that's joined this meeting to know that nobody is helpless. And if anybody is making a sham of their disability and accusing them of making a falsified disability, then I say that the person that makes that accusation is making it in bad faith and is making it with sin. And this is not acceptable. That's all.
thank you for your comments. Again, I do want to apologize that this is not the forum for us to address individual case level concerns. And in the last 25 minutes of this meeting, I do want to still call out recommendations, suggestions that this group may have regarding the TA process. And having said that, I am going to turn it over to Nancy.
I want to share with Brian Twan transcript because I heard him, but I didn't hear anybody on your end.
Nancy,
Yeah, can you hear me?
No, it's very difficult to hear you. Can you start over again, please? Oh, Nancy, we don't hear you at all anymore. Nancy, do you want to try once more? It sounds like the reception may be going in and out. Nancy at this point is the only one with their hand raised. Is there anyone else that would like to make a comment, make a recommendation, make a suggestion? I see that Nancy has disappeared, so we're going to go ahead and throw this over to Deb at this point, and Nancy, we can come back to you.
I'll ask this question while Nancy's working on getting back online. I'm anticipating probably, I bet you $1 million this winter we end up with another health emergency. Is there any plan? Well, I guess you can't answer the question, so that I hope that they will address this to the public online. If there's any plans or contingency plans this winter for dealing with technological changes during online administration again, should that happen. I'm probably going to have to postpone my testing until February now. And I actually it was beyond just the technical problems with the test dropping multiple times while we were taking it. There was also changes in the formatting and instructions that they didn't let us know about in time enough to ask for disability accommodations. For instance, I was told that I was going to have to stare at my screen the entire time during the test, and I couldn't move my eyes around the room. I'm pretty sure that there's other people that attended this meeting that, there are people that can't do that because it will trigger trigeminal neuralgia or cluster headaches, which I have both. And so, yeah, by the time we got down to day 3, both of my eyes were nearly swollen shut and it's not running down my nose. They were recording this whole thing too. It was very embarrassing. But it's actually one of the most painful conditions known to man. So when you're going through it, you want to stop it and stop doing whatever's causing the pain. And instead I had to spend 8 hours, 3 days, more than 8 hours, 3 days staring directly at a computer monitor, even though it was causing cluster headaches and I couldn't move my eyes around. And the problem is that when they changed, it was an emergency. So, I haven't made a big fuss about this because, it's force majeure. What can you do? Everything just went to the wind. So instead, this time around, when force majeure comes up again, maybe we can take some plans and take the lessons that we're learning from the last times around. I've sent you some messages about this, and make sure that we're really, really clear ahead of time with what we're doing with the changes in testing accommodations, so that people have time to respond to it and say, oh, well, that wasn't going to be a problem with the in-person test, but it's really going to be a problem with this. And that'll give us time to adjust to it too, because the truth is, the reason I'm not barred right now is because this whole thing wasn't done properly the first time I took it, and I haven't had a chance to retake the test since then. So, anything that we can do to be really, really proactive about any upcoming health emergencies, especially working on technological problems for online test taking, will help us with the disabilities accommodations. I think that at this point, knowing that we've had so many problems with it, it would probably be a requirement for us to start considering contingency planning now and taking input from people on how specifically to do that. Like one simple option is to use a testing accommodations platform that allows you to record two different screens or to record a different screen than the main screen on the laptop. There's all these little tiny technical details with trying to change your testing format to 100% online and still proctor it that need to be addressed well in advance of an emergency. So that's a suggestion. Maybe we can, I'm definitely going to that meeting, but we can work on just any anticipated upcoming emergencies that might be happening. I don't think that this would just be dependent upon the Supreme Court ruling, the California Supreme Court ruling for this other case either. I think that we have to consider that the larger circumstances that are taking place in the world and know that even that case may not apply to what's happening this winter. So yeah, I don't know. It's an idea. Thanks.
Thank you, Deb. I did make a note of your suggestion regarding the contingency plan in the health emergency, if there is a health emergency. So thank you for that suggestion and that feedback. Let's go ahead and try Nancy. Nancy, are you able to make comments?
Yes, I think you can hear me now.
We can hear you. Thank you, Nancy.
So it's not a comment really, but the young man who is a diabetic and wanted to know how to see he said he couldn't see the full transcript. Maybe he doesn't know that you have to hit the more button to the right. If you hit that, then it says view full transcript. Then he can read the actual full transcript. That's all. Just wanted to give him the information. I didn't find it until halfway through.
Thank you, Nancy.
You're welcome.
So at this point, I again do not see hands raised. Are there any people in the San Francisco or the Los Angeles offices that would like to make a public comment?
LA here, no new members of the public have entered. Same here in SF.
Thank you, San Francisco. Thank you, LA. And I do not see any hands raised on Zoom at this point. I'm going to go ahead and just give us a couple minutes just to see if anyone is going to join us and would like to make comments. Okay, again, I just want to thank everyone for attending this meeting. Want to do a call out for anyone that would like to make a comment or anyone that would like to make a recommendation, a suggestion on the testing accommodations process. I don't see any hands raised at this point. So I might go quiet until we get somebody that would like to make a comment, a suggestion, or give some feedback.
See, there are two members with their hand raised hands.
Sorry, my mouse and my computer just went out. Okay, I'm back. I am going to give a chance to those that have not yet, I believe have not yet given a comment. So I am going to promote Amelie. Amelie, are you here to give comments?
Speaking, yeah, can you hear me? So,
Thank you, we can hear you.
thanks. This was a lot on my end, so I can only imagine how it feels on your end. There are comments I think I'd like to say, but I think I'm just trying to also digest everything from the last few hours. Will there be an opportunity to provide additional comments after the fact? And will they?
Yes, thank you. We will take written comment after the fact. I need another staff member to give me that email address for whoever has it. We would love the written feedback to be submitted to an email address that we have set up.
Yeah, that's all. I'll wait for the email and
Yeah.
Yeah.
Okay.
Right, one last thing. Is there a deadline to sending that out?
We originally called for a deadline just to get everyone's thoughts and feedback in order. But as I understand that, we are still going to continuously seek feedback recommendations. We'd like to get the feedback whenever you can give it to us. Of course, sooner the better, so we have time to process it and share it, but there is no deadline for submitting your feedback. And it looks like the feedback is going to go to one of our staff members. Her email address is listed on the agenda that was posted on the State Bar website today. It's devin.mcfarland@calbar.ca.gov. And again, it is posted on the website, on the agenda that is posted on the State Bar website.
Okay.
And Amelie, did you have another comment or did you?
As of now, I think I'm good. I want to digest first before I. Thank you.
Understood. And the other hand that I now see raised is Alex. So we're going to go back to Alex.
Yes, I just wanted to make a brief comment. It's in regards to the appeals, and that I hope that the State Bar looks closely at the appeals and looks closely at any inaccuracies that were listed as justifications for reasons of denial. Because if there's clear evidence that those were based on inaccuracies, then that should justify the reversal of the appeal. And that I hope that in the appeals process, your department looks carefully that when there was justifications given for the denial, and when that there is clear evidence that those were in fact false, that they should go ahead and reverse their decision immediately and provide those individuals with the accommodations that they requested and they lawfully deserve. That's all.
Thank you. And at this time, again, I do not see any hands raised. So I will go silent for a few minutes, just to allow anyone to raise their hand if they so desire.
Hi there, thank you. I do see.
Thank you, Pirk. I do see a hand, Pirk.
Thank you. Okay.
Teak, okay, comma.
Hi, this is Benjamin Cohn. I wanted to let you know that I have been communicating with a few other interested stakeholders, and they were not able to make this hearing today due to scheduling conflicts, but I wanted to make you aware that there are people who want to be heard live rather than through writing that are still hoping you'll hold another one of these at a different time that they hopefully can make work with their schedules. So if that is something the State Bar can do as it continues to review these reforms, I know there's interest. Thank you.
Thank you, Benjamin, for the feedback that there are other people that would like to be heard in this type of forum and not just a written format. That was heard. And let's see, we have 3 minutes left to our regularly scheduled 4 o'clock end. I do again encourage anyone that would like to make a recommendation, a suggestion, or perhaps just comment on their experience with the testing accommodations process. Please do so now. Happy to hear you. Taking lots of notes. And at this point, I don't see any Zoom hands. I am not going to call out for Los Angeles and San Francisco rooms because both rooms just checked in with me and told me that they do not have anyone in their rooms at this point. And so I am going to go silent once again. Just wait for anyone to raise their hand. Thank you. I still don't see any hands, but I did just want to take a quick second to really say thank you to everyone that had spoken today. I appreciate everyone that came to listen and give feedback. And again, we encourage you to write in comments if you so desire. Okay, that is going to conclude this meeting. Again, much appreciation for those that came and for those that spoke. And our transcript of this meeting will be posted on the website. And thank you again. Have a great day.